Mr. Cathy, are you ready if we go on the record? All right, and Mr. Boring also ready?
Yes.
All right, Ms. Womble, can we get started? Great. We're going to get on the record in the inquiry concerning Judge Gerald Johnson. This is the hearing panel of the Judicial Qualifications Commission in the ceremonial courtroom here in Cobb County. And we are here for the hearing on the formal charges that were brought against Judge Johnson in March of this year via complaint number 2021-416. If we could have the appearances for the director's office first.
Good morning, Your Honor, Your Honors, and members of the hearing panel. Chuck Boring, Director of the JQC.
Good morning, Courtney Beal, Deputy Director of the JQC.
Good morning, both of you. And on behalf of Judge Johnson.
My name is Dennis Cathy.
Your Honor, I'm Adam Harkness.
And this is Judge Johnson.
Good morning, all of you, and thank you for being here. My understanding and what I've relayed to my colleagues, Judge Lopez and Mr. Hyde, is that the expectation is that we would get through the presentations from both sides today, that it's a one-day event, primarily because the two sides have agreed to, stipulated to most of the facts. We've reviewed the formal charges, which contain a summary, a very high-level summary of the facts. So we've got a basic background. But it would be helpful if either Mr. Cathy or Mr. Harkness or Mr. Boring or Ms. Veal would describe how you envisioned the day going. It was our sense that most of the presentation will be about mitigation, perhaps, and what is the appropriate outcome as a result of the largely stipulated two facts. So I'd like to get an overview of how you envision things going, who's going to be presenting what. And I don't mean which lawyer would be doing what, but there's going to be just a recitation from one of the lawyers about the facts, or there will be a witness, just so we know what to expect. And then I want to talk briefly about confidentiality, which is a concern that was raised in the memo, Mr. Cathy, that you and Mr. Harkness provided a while ago to the panel. We want to be sensitive to that. This is a very public proceeding. This courtroom is open and this proceeding is being live streamed. So if there comes a point where we need to be thoughtful about how information is presented or discussed, I want to make sure that we as the panel are sensitive to that. And we'll take guidance from the two sides, but the default will be open public hearing. And that's the way we'll at least initially move forward, okay? So why don't I start with you, Director Boring, as to your thoughts as to what the format's going to be, and then certainly hear from Mr. Cathy, unless you've agreed to do it the other way around.
Oh, but I would like just
And one quick thing, if you could make sure you're speaking into a microphone, either at the podium or council table, it's fine to stay at council table, but I could hear you, but it's not just about the three of us. It's also the general public who is absorbing this through the live feed. Okay.
I wanted to just take this opportunity to renew my motion to seal the proceedings, and we made that today. And we've had some discussions about it before, but I want to make sure that the case will repeat to the case issues of mental health as recognized early on by as recognized by JQC, and we believe that during these proceedings it should have been handled without confidence. I think evidence is ready. I'm renewing my motion. You're about to address it. You're ahead of me, so I just for the record want to say that motion is still in the record.
Sure. Before you leave the podium, my recollection from discussions we had is that while you reference incapacity and the separate collection of JQC rules that govern proceedings related to incapacity, that's not actually the route that you intend to proceed, nor was it the nature of the allegations that the director brought. And I think what you highlight in your memo, without going into its contents too much, is that there is an intersection here, but this isn't pure incapacity, which would be a very different type of proceeding. It is an acknowledgement that there are formal charges, an element of which may have been temporary incapacity or issues that contributed to the conduct of the alleged conduct of Judge Johnson that resulted in these formal charges. But I don't want to be misremembering or misinterpreting.
You're correct. Now, the point though about the entire thing is that at the IP level, there was abundant evidence that we were dealing with the issue of incapacity in some fashion. And at that IP level, further discipline agreement can be obtained and sought. To me, the spirit of the JQC was that these type issues are handled at the IP level where it can be confidential, and exploring exactly the role of the incapacity issue can be fleshed out. We told the IP, here we are, we'll submit to any examination you want. Here's our HIP releases to get anything. And it's the only judge that I have had that wasn't invited down to talk to you. So we are where we are. So I think those incapacity issues cannot be, they are the part and soul of this case. So I don't know where the dividing line is. It's cause contributed to, but we'll present our evidence.
Okay, one last question on that topic. First, an observation and then a question. The IP and the director, considering all the information that was before them, elected to move forward with formal charges rather than a deferred discipline or something else. And so we as the hearing panel can react only to that which we receive. And we received the formal charges, which are by the rules and really by law, public pleadings. And so, as you observed in your memo, in some ways it was almost too late to get the genie back in the bottle. So here's my question. If this were a purely criminal proceeding, and it's not, it's quasi-civil criminal as you've observed, but if this were the trial or even just a plea hearing for your client because he had been arrested for and ultimately indicted for aggravated assault because he allegedly pointed a loaded assault rifle at a law enforcement officer, the plea colloquy would not be something from which the public could be excluded simply because you, in mitigation on behalf of your client, wanted to share with the judge or judges concerns about your client's mental health and how that might explain the conduct that resulted in the criminal indictment. That wouldn't be something that would be, you might file something, parts of which would be under seal, but if you wanted a judge to consider in mitigation in thinking through what should the consequences be for a guilty plea to aggravated assault, the things you're worried about, I don't believe the law would authorize a judge to seal the proceedings. They are certainly personal, but I don't think it would rise to the level that would, if the AJC was knocking on the door saying, we would like to be present for Dennis Cathy's client's plea hearing, and the issue as well, but Mr. Cathy wants to explore a little bit some of the mental health issues that his client was working through. I don't think the case law would allow a judge to seal that.
We prefaced this policy with our own answer. We are not a criminal proceeding. We're not even remotely like a criminal proceeding. For instance, in a criminal proceeding, if this criminal violator is right, say we have a right to go to the IP and make our pitch for impairment. In the criminal world, if that right is violated, what happens? Maybe the case gets dismissed. There's no provision in the JQC for a case ever being dismissed. All you can do is say, don't do that again. Let's do better in the future. So this is not analogous at all to a criminal case. Built into all the rules are recognition that impairment rules exist, and especially one involving alcohol, which our American Bar Association says is a disease and is a treatable one. So we can't draw that analogy just like it's not a civil case. If you violate your rules of procedure in a civil case, the answer gets started, the complaint gets started. Those are, all we can do is this panel is the sales, this is the fail safe. When something gets voted out, you know, I think you can go back to what that's on the panel for the evidence. That's what we're asking you to do. Now, Judge is right, which we think is built in. We discussed his mental issues, his addiction issues, and confidentiality lost forever. There's no way to get that back. So what can we ask you to do? Proceed with confidence. Now, it's not what we should have had. It's the best you can do. I think you can do it. I think there's discretion vested in this panel. You and I talked before about the vacuums that occur some places in the group. We talked about some things. I hope this will bring about one. That helps the system. You don't help my client. So.
Understood. Did you have any questions for him on that, or want to hear from Mr. Boring?
I'll just briefly cover this issue, Judge, just to make sure our position is clear. And I think you hit the nail on the head in delineating the difference between an incapacity proceeding and mitigation to a disciplinary proceeding. Incapacity is very narrowly defined in the rules. Basically, it's saying that a judge, per some type of impairment, is not able to fulfill his duties as a judge. I think their argument here is going to be the exact opposite.
Right.
And so
You can't really have your cake and eat it too. And I think this is the discussion we had before. If you want the protections built into the rules for incapacity proceedings, then you'd need to be moving forward under the premise that your client is not able to serve right now. Maybe later he might, but the thrust of what I understand we'll hear today from Mr. Cathy and team is that Judge Johnson is very able to return to service. Look at the rehabilitative steps he's taken, et cetera. So, but to Mr. Cathy's point, it may be that there's a gap in the rules that needs to be addressed so that one could, in a more full-throated way, explore mental health issues that contributed to formal charges about which there ought to be public discussion.
I agree with that, Judge. The only things to be put in any formal setting or public setting are the facts of what actually happened. And so, you know, the tool for him to basically attempt to get confidentiality assistance per mental issues would have been to file something under Rule 27, which would have been asking, basically saying that he is temporarily incapacitated, and would have had to then file this, and he would have automatically been temporarily incapacitated, and it would have to show that he was not fit to actually serve on the bench at that time because of some mental impairment. I think we have the exact opposite here. I think our rules do not allow for sealing of the records just in and of themselves when a defense is made in mitigation regarding alcohol abuse or something of that nature. And of course, we'll be sensitive to any medical information if they tendered medical reports and were redacted and that type of thing. I completely understand that, but just from a general sense, I just want our position to be clear as to why we handle things the way.
Sure. What's the roadmap for today, as you understand?
Now that I was going to give that, we already got through part one. So part two, Judge, I expect I will give Your Honor, I know you all have read the formal charges, give you a roadmap for what the facts actually were, as well as, I guess, a mini opening statement. As far as evidence or witnesses, we only have two things to admit. We have first a stipulation with the defense of Judge Johnson admitting all of the facts in paragraphs 1 through 9, and then admitting to violating the Code of Judicial Conduct in counts 1, 2, and 4. We're not proceeding on count 3, as that is one we've researched and gone back over the evidence again. And while we think the conduct alleged in there violates the other 3 counts, it may not actually violate count 3. So we are not proceeding on that count.
All right, so everyone is clear who may be observing. Count 3 alleged that Judge Johnson effectively, this is my summary,
Yes.
used his office, his position to try to get favorable treatment. Specifically, stop recording officer so-and-so, our exchange. I'm a judge, let's not get this on tape. Let's keep talking, but turn off the tape. And you have concluded for various reasons that those allegations, even if proven, wouldn't constitute a violation of Rule 1.3, or it's as part of the back and forth, the director is no longer pursuing count 3.
I think in negotiations, but also legally, I think the absence of him using the position of judge in making that request Throughout it, he's referring, just to give you a preview, to the lieutenant as Travis. They have a long-time relationship, friendship. And so in that regard, we still are alleging it was improper under certain rules, but not necessarily under that one, based on some previous decisions over the past 2 years regarding 1.3.
Got it. It doesn't rise to that level of, don't you know who I am? I'm so-and-so.
That is correct.
You need to treat me differently.
That's correct.
Okay. Yes.
And then, I'm sorry, and then we also, the second piece of evidence to introduce is we do have the video recordings from the dash cams to introduce into evidence. I do have one official that I'll present for, I guess, I don't know if you all are going to watch them together. We have copies for all three panel members, so I'll go ahead and submit those extra copies as well once we get to that point. As we get, just to foreshadow, as we get to the argument on what the proper sanction is, it's listed in the formal charges. It's willful misconduct in office and conduct prejudicial to the administration of justice, disrepute. We're not proceeding under the argument that this willful misconduct in office, having researched a number of these cases and had these decisions over the past couple of years. This was nothing, an act within his judicial capacity when this happened. So we'll be presenting under that other arm of the proper basis for seeking disciplinary action.
Got it.
So we have those two pieces of evidence to submit. Mr. Cathy, then I expect he will present his evidence. He's told us he has, which most of the stuff he's going to submit to you is already in the record. We're not going to have any objection to the submission of his character letters and that type of thing. He has two witnesses. I believe Judge Johnson is going to testify, and then they have an expert regarding the alcohol issues with Judge Johnson. And then I think we'll be proceeding to argument at that point.
And when you say things are already in the record, we of course have nothing. They would be things that I know Mr. Cathy submitted many things to the IP as part of the back and forth of establishing the steps that Judge Johnson had taken post-incident to address some of the concerns. That's what you mean by in the record.
Yeah, well, I also mean like some of his exhibits are the formal charges. They're his response to the formal charges. Those things, the consent order to suspend Judge Johnson. Okay. That's those things.
Literally the record of this case.
Yes, okay. Yes, sir. But he also does have some, like the police reports. We don't have any objection. We actually are agreeable to have those presented to you all. So,
okay.
But I think that's the roadmap, the line of events we expect this hearing to take today.
Yes, sir. Yes, but I just want to make clear that your motion to have these proceedings occur in a closed setting or under seal, pick your term, is denied, and that will continue in the public fashion that I believe we're obligated to. But I will renew the invitation that if there are specific items that you want to have made part of the record that either need to be redacted or perhaps should be made part of the record under seal, I believe we have the authority to do that, and we'll certainly exercise it if that's appropriate.
At the time that I believe that occurs, if you allow me to make a profit, it's outside the record. Mr. Boring was correct to present two live witnesses, Mr. Johnson, Judge Johnson, and his therapist who was here to testify. Now, in the explanation of the record, I prepared the exhibits which I've shared with the record before. I went through packets, they're indexed, so they have a tab. The ease of not following these.
Thank you.
There are various items, some that you read, and some are perhaps.
As long as Mr. Boring knows what they are. And
I know what they are, and I think if he's going to admit them when we get to that point, I'm not going to have an objection. So okay. I have no objection to you all being presented with them at this point already.
I've sent them to him earlier, and if I can proceed then, as you know,
Judge, I think.
When you say proceed, tell me what I know Mr. Boring was going to give an opening.
Yes. No, I haven't started.
Okay. All right. So Mr. Boring, when you are ready.
And again, I'm getting used to this new world of no jury, so I know I don't have to do as much of the song and dances before, but as you all read from the formal charges and probably gathered already here, this is a simple case. It's going to be straightforward. And while there's going to be testimony, it is a, I guess, a heart-wrenching situation at times when you look at somebody who's done so well in their lives and who is really taken a fall. What do you do with that? But with the evidence here that you all have already been presented with, you're going to have the stipulations you're going to be faced with, it's going to be an inevitable conclusion. And that the inevitable conclusion is based on the violations of the Code of Judicial Conduct in this case and the actions by Judge Johnson, given his role as a magistrate court judge, while he can be redeemed, it should be rehabilitated, it should be thanked for doing what it takes to fix the problems he had. He can no longer sit as a magistrate court judge in Habersham County, based upon the conduct and retaining and keeping the public's confidence in the judiciary. Stipulated facts in this case, as I told you, we're stipulating all the facts in the formal charges. Also, as to the violations of count 1, 2, 4, Judge Johnson has agreed with that. You will all have videos, and when I tendered those, I actually have instructions on how to play them properly and which video is which on the flash drive. Count 1, he is charged with violating Rule 1.2A for failing to act in a manner promoting the public confidence in the judiciary. And that's based on several things you're going to hear about. This domestic event between the defendant and his wife, in which he had thrown stuff around the house. They were both intoxicated. He was completely inebriated. He had taken his wife's phone from her, banged on her windshield and cracked it at some point after she'd gone into the car. Also, for possessing and repeatedly firing an AR-15 in the backyard while very intoxicated in a residential neighborhood. Most egregious, and this is why we're here, for answering the door when the police came to check on what the noise was. They go to Judge Johnson's house. I'm like, hey, we know him. We'll go over there. Lieutenant Gerald shows up, and you have the door flung open and an AR-15 pointed out, with Judge Johnson saying, I didn't call no law, or I did not call the law, something to that effect. And then also, you're going to hear about the issues of the judge on several times while talking to the police, asking them to cut off the camera, to turn off so it's not recorded. He didn't want them to hear what was going on. And understandably so when you hear the facts. Count 2, he's charged with violating Rule 1.2B, which is the corollary of 1.2A. Ties right into that. And count 3 for violating Rule 1.1 for failing to follow the law in several.
It's count 4.
Excuse me, count 4, yes. For failing to follow the law, which is obvious here. By clear and convincing evidence, the facts obviously show that the offense of aggravated assault was committed, several counts of reckless conduct, criminal damage to the car, or cracking the windshield would be a criminal trespass, I believe, simple assault, taking his wife's cell phone, several different things that would be violations of the law in this case. Factually, back on October the 18th of last year, 2021, around 7:30 p.m., the police got a 911 call about gunshots. So they show up and they go around, they respond, and the person that had called said, hey, I heard a male yelling and then banging on stuff. Sounds like banging on, I think, a can or something like that. The police couldn't find anything. This Lieutenant Gerald, with the Habersham Police Sheriff's Office, couldn't find anything. So he went to the one place where he knew somebody in the area. It was Judge Johnson's house. He goes up to the house, and you'll see it on the video. He walks around to the front and rings the doorbell, and Judge Johnson opens the door with an AR-15 and points it at the lieutenant. Lieutenant freaks out. You'll hear it on the video. He starts breathing heavy, starts almost like laughing, scared, runs, goes behind his patrol car off to the side. And he recounts that Judge Johnson obviously was intoxicated during this period. I don't believe he remembers saying this, but it's stipulated to Lieutenant Gerald said that he said, I didn't call the law, or did not call the law. Soon thereafter, Judge Johnson then says, I'm not armed. He put his gun down. Lieutenant Gerald comes around and starts talking to him. Notices immediately he's inebriated, he's slurred speech, he's stumbling around, even though he'd been walking around with this AR-15. Also notices his wife, Judge Johnson's wife, very upset in the house as well. The defendant admitted he didn't want firing his gun in the back of his porch. We found out later from talking with our office, he had been here, he and his wife had been arguing. She'd been in another room and the noise was irritating him. He went and went into the backyard and started firing the gun while intoxicated. You're going to hear as well, they had been arguing that day, that at some point he had pointed the gun at himself and threatened to harm himself, that he had been throwing things around the house. He'd taken his wife's cell phone. She had gone to her car at some point, and when that happened, he came up and banged on the windshield. And you'll hear that he thought it was with his hand, but his wife recounted that it was with a Swiffer handle or something, and did in fact crack the windshield. And a Swiffer handle was found near the car. But there had been damaged items in the home, where he'd been banging on a trash can. And then again, like I said earlier, he asked them to turn off their cameras when they're talking from this. Obviously, Judge Johnson had a close relationship with Lieutenant Gerald, and that may be playing into a lot. And you'll hear from Mr. Cathy several times saying, they never made an arrest. They never arrested him for these incidents. They thought it was a mental health issue. But it's stipulated to, we talked to Lieutenant Gerald, and he said at that time, when Judge Johnson pulled the gun on him, he feared for his life. He feared for his safety. And you're going to hear when we talk to Judge Johnson that he actually said, you know what? If I'd been in the same situation, I would have shot him. And I would not have blamed him if he had shot me at that point. After Lieutenant Gerald showed up at the scene and talked to Judge Johnson, tried to get the stories from both sides, Judge Johnson wanted to stay at the house, but his wife wanted to leave. He eventually was convinced to go to his mother's house, some 7 to 8 miles away. The police took him there. They asked to escort him up. He said, no, it's fine. I'll go into the house. They get a call later. Judge Johnson had walked back that 7 to 8 miles to the house, and now he's back at the house, and the police respond again. They talked to him again. At that point, his wife was not cooperative. Judge Johnson was not cooperative with letting them stay and talk anymore, and they left. Judge Johnson, you're going to hear as well, his wife eventually recanted and said that he did not break the windshield, but Judge Johnson admitted to us, to our investigator and investigative counsel, Jeff Davis, that in fact he had actually done it. So again, while they're tragic and sad facts, the facts are very simple in this case. And so after you hear that, and after you've heard the presentation from Mr. Cathy about, a problem that his clients had, we're going to ask you to, in the end, with findings of fact, find that he's violated these codes of judicial conduct rules, and that the appropriate level of discipline in this case, and the only one based upon his job, what he has to do on a day-to-day basis, and what he did by voluntarily taking that alcohol into his system and acting that way, the only possible level of discipline that we think is appropriate is that he have to step down from his role as a magistrate judge.
Thank you, Mr. Boring.
Thank you.
Mr. Cathy, do you want to make a statement now, an opening statement, or do you want to?
I think it would be easier for kind of follow the evidence.
Okay.
I'd kind of like to make an opening about what I'm gearing up to try to prove.
Okay.
And the two things that the opening that struck me, and Mr. Boyd, and of course, our relationship in this has been more professional. Going to it, we certainly disagree, but it's an idea that we can be adversarial,
disagree with the recommended sanction, not about the recitation of the facts.
Not at all. There are little things that in the overall scope, not a game changer. But the one thing two things strike me. One is simply say, well, he can't go back on the bench. Now, if that's true, number one, we have a rule of suspension in our rules. That means each judge who has some problems, and we recently had one with scope of problems much wider than this, so we'll have to go back on the bench. Every judge who is suspended for any period of time faces that. They just can't go back on the bench. Well, in all areas of suspension, they do go back on the bench. And I think the record of this panel will look at those judges that go back on the bench usually don't come back with a complaint. So this argument that he can't serve anymore defies how we treat suspended judges. The second thing is to say, well, he's now rehabilitated, but he still shouldn't serve as a judge. To me, that means he's not rehabilitated. If he's rehabilitated, that means you're back like he was. And if he's back like he was, why couldn't he go back on the bench doing magnificent jobs that he was doing before? With that, I will say those are the two things that I want to press on this panel. One, suspended judges go back to work, and often go back to work with great efficiency. A lot of times, more understanding, more empathy, more compassion, more understanding of the system. So that can happen. And rehabilitation, I believe, until I involved in this, the goal of all of us was to rehabilitate a good person, put them back, and make them whole. You're not making them whole to say, good luck. You're not making anymore, but you're still unfit. That's what you say. And that's not allowed rehabilitation. This is what we were shooting for.
Where's your guy? The question, I think, is how to get the overhead projector to work its magic. Oh, you're delivering things too. Thank you. Thank you.
And y'all may think I'm dwelling on this confidentiality and psychiatric, and I am to an extent. But
Oh, I think I'm supposed to control that. I'm sorry. Document camera. I'm back. My apologies.
Well, then I don't feel quite.
Yeah, I'm your guy.
Okay.
Remember that.
All right. This is what, as big as I can get.
If you want to zoom in, that part I cannot control. That's you.
Ah.
There you go.
There you go. All right. What we asked for, what we were shooting for, was this JQC rule, a deferred discipline agreement. Now, once it's voted out, y'all can't do that. But at the IP, we could have done it. It's somebody that wrote this rule. Really, we're aware, I think, of what psychiatric issues, addiction issues, mental health issues are all about. A deferred discipline agreement is a confidential agreement between the judge and the investigative panel for the judge to undergo treatment, participate in an education program, or take corrective action. It's only available as a response to misconduct that can be addressed through treatment, education, or rehabilitation program. A deferred discipline agreement can only be entered prior to the formal charges. We were hopeful for it and asked the IP for a deferred discipline agreement. Now, the reason that we thought that we would have some ear of the panel was when Judge Johnson, by the way, participated totally without counsel, interview, cooperation, totally cooperated, and resulted in an order that he was suspended by consent. That consent order that was placed in the Supreme Court, drafted by the JQC, Mr. Johnson didn't have counsel at the time, but you can see some of the things that he expressed suicidal ideation and concerns for his mental well-being. Now, those are the words put in the order by the JQC. Now, it goes further. Judge Johnson expressed concern with his well-being and admitted to suicidal ideation.
Mr. Kathy, is the document that you've got on the screen also in our?
I'm not sure it is, but it's in the record. It was filed with the Supreme Court, Your Honor.
But what is it?
Big word?
What is this document?
Oh, I'm sorry. I thought this is the consent motion to suspend Judge Johnson from his active practice. It's number 4 in my package.
Okay.
It should be in there.
Thank you.
It is in the official record.
No doubt. I just,
So-
one of the panel members was
Yeah,
wanting to
and-
follow along.
and, So to me, the recommendation or recognition by the IP that we have a person who's expressing concern for his well-being, and the JQC obviously expressed the same thing, recognized suicidal ideation. And the thing that struck me, and maybe there's nothing that is more concerning to us than suicidal ideation. State Bar of Georgia has been a leader in suicide prevention. And the suicide awareness program, I might point out, of the state of Georgia State Bar Association applies to lawyers and judges, and it doesn't say judges who are lawyers, it says judges. So here we have a person who the initial consideration by his local law enforcement, and to suggest that Travis Gerald knew him and no charges were made. The deputy saw him, two other officers, the sheriff saw him, and I think in my package you have the sheriff's recommendation, a press release where he says it's a mental health issue. He released that to the press. So and then finally the captain of the police department said it's a mental health issue. So everybody from the top sheriff down to the captain, down to the troopers on the street said we facing a mental health issue. And I'll read you some of the statements, and you'll have it up there. My little package I gave before. I hear this thing. By the way, I just pulled some things that have been prominent lately about. I just did a quite scan of the awareness in our bar activities of the suicides that are replete through our profession that caused us to have this concern about suicide. And is it just lip service that's all we're talking about, or do we really want to save a judge and a lawyer's life? I'll just read to you from my incident report number 1 in your package. On the last page, it refers throughout that, it refers to Laura, that's the wife, stated you'd been making suicidal statements. And it was to her, you go on through that, another officer mentions the suicide. And then this is the press release from the sheriff, which is a part of your tab 3. The sheriff released a press release because people, what's going on with our judge? And he says, based on the intoxication level and other issues that Johnson's faced, the deputies, out of concern for Johnson's health and well-being, I have no alternative but to report the incident to the JQC, which is the oversight for judges of the state of Georgia. That's your sheriff. Now, if there was a cover-up, the last person you would call would be the JQC, because there's no cover-up. It actually illustrates that I think our Habersham County sheriff was pretty enlightened about what he saw and what he was aware of. Not a cover-up, exactly the opposite. Now, I've discussed about that enough. I think y'all know that the issue is drawn that we think this is a straight mental health issue. And by the way, when he met with the JQC at that time, he was impaired to be a judge at that time. And when he was met with them and he was having suicidal ideation, at that time he was impaired. He certainly expected the IP to monitor his progress. They didn't. So he did what we expected the IP to do. He took it on himself and did it. Now, I'm going to talk about the mitigation factors. It sounded like this, the one-man crime way of breaking out. These are the mitigating factors in the formal charges themselves. And you say, well, I thought you admitted them all. We did, but we can spin that we committed aggravated assault on an officer, and that didn't happen. First of all the events in this occurred in the privacy of his home over just a very few hours. Very few hours. Secondly, he had never been any allegations of misconduct on the bench, never been any allegation of misconduct off the bench. When they drove up to the judge's home, the police officer did not use his flashing lights. He didn't have his siren on. He flashed his flashlight outside a little bit. The judge has a translucent front window. He can't see out there. He could see light. The officer knocked on the door and he did not announce himself. Judge Gerald, this is a deputy, Judge Johnson, this is deputy sheriff. There was no lights, no siren, no announcement. He opened the door and just Judge Johnson was there with his gun. Immediately. Now, you will hear, yeah, sure.
I don't know if this is working.
It's working.
I ask you, I understand that what your argument is. My response or my question is, isn't it a reasonable expectation that if you are firing an AR-15 in a residential neighborhood, that someone might come and knocking at your door and that person might be law enforcement?
Maybe in Fulton, DeKalb, not in Habersham. I mean, it really is a rural area. I hear gunshots almost once a week. So I don't know that. Now, if you're the shooter, I think you might expect, yes. And so I'm just telling you, but what he did, opening his own private home to somebody he didn't know with a gun in his hand, is not a crime. Now, it was imprudent conduct, and he was obviously drinking. So I'm not going to run away from that. But it was not aggravated assault where he meant to intimidate somebody. He's in his home, and we're not denying that. But to draw down on an officer is not what happened. Spontaneity. And you will also notice on the tape, if you listen to it, there the statement of, I didn't call the law, is not on that tape. It's not on that tape. We've listened for it. We're not denying he said it. He didn't remember what he said. And he told the investigator, he said, the night's a blur to me. He was very intoxicated.
Mr. Kevin, how many feet from the roadway was the door to the house?
25, where the car was parked. I'm guessing. That's just my guess. But the car was parked in a defilade position. He couldn't see the car. So even when he opened the door, he couldn't see the car. There was no lights. He could see the officer, and it took him a moment to process who it was. Once he saw it's Travis, he says, this is not any problem. Now, I'm not denying it. I'm mitigating it. It wasn't drawdown on an officer. So keep that in mind. Don't say, oh, Kathy, now y'all have admitted this. This is the difference. Okay, then on October 26th, he sat down with the JQC. He never called anybody. He confessed. He'd had an hour and 45-minute conversation going back with all his marital difficulties, everything that happened. And then this order was entered where he's leaving the bench because of his mental problems. The next thing that happened, tab number 5, was the IP rights, Judge Johnson, and tells him, you know, we've got the charges against you. And then tab number 6 for your consideration is Judge Johnson's response to the IP. And he goes without equivocation to the underlying incident. Then he talks what the JQC did. Then he talks about the disease of alcoholism, because at this time he had been in recovery for November, December, January, 3 to 4 months. He'd been in recovery at this time. And he lays out what he had been through. Then he says, let's do a deferred discipline agreement. The response to that, and he cites the people he has seen. He makes a proffer in there. I will give you a HIPAA release to let you get on my records. You can have me examined, which the rules we just went over provide for. I will be examined. Here's my HIPAA releases if you want them. Let's join me in doing a deferred discipline agreement. The response we got was formal charges. Now, I don't know how the IP assessed his mental state without hearing from any evaluator or provider. I've said enough about that. I think y'all are tired of me saying anything about that.
Now, after the mediation, excuse me, after the event and his IP, and then they voted out formal charges, concurrent with his being suspended, the first thing he did was he went to a rehabilitation doctor and said, what should I do? And Abby Brewer says, Gerald, I think a nice place for you is the Blue Ridge Mountain Recovery. He went in for 35 days. An excellent recovery facility. Upon his discharge, he agreed to do 90 consecutive days of Alcoholics Anonymous pursuant to his discharge agreement. And contemporaneously with that, he went into another intensive outpatient for 12 additional consecutive weeks of, that's 3 months. So we're now into 6 or 7 months of sobriety. Now, in order to assess how he was doing, we sent Judge Johnson to a therapist here in Atlanta named Robert Obst.
Can you spell the last name?
OBST. And Dr. Obst is someone who does, among other things, rehabilitation services for physicians on behalf of the Composite Board of Physicians and Surgeons, working with them to rehabilitate themselves to get back into their profession. He also is quite conversant with the bar because he does evaluations for the bar examiner's fitness board. As y'all know, we have a fitness board, and occasionally somebody will have a past with a fitness issue, and he assessed those people. So from a medicinal standpoint, a medical, psychological standpoint, and he will testify here today and will give his evaluation of, and one reason we wanted to use somebody who had no confirmational bias because he had treated him. We wanted to have somebody do an evaluation, number one, see if there's anything underlying other than alcohol consumption that would cause this behavior, like schizophrenia, bipolarism, anything like that. And we wanted to evaluate his treatment thus far and make assurance he had no underlying problems. So those are the things he's done. And he's been 13 months sober, and he'll tell you about his rehabilitation efforts. And I appreciate the board indulging me. I only went this long because I think it'll help you. We'll evaluate the evidence and put it up. Thank you very much.
Thank you for the context. We appreciate it. Mr. Boring?
Thank you, Judge. I just have 2 exhibits to admit. First one is Exhibit 1 for the record. The stipulation between the parties. Exhibit 2 is the video with instructions for the record, and I'll give you the other 2 copies for the other hearing panel members here in a sec.
Any objection to the directors 1 and 2?
No.
Mr. Boring, were you planning on playing the video, or you're making it available and here come more copies so that we can view it at our leisure as we're conferring?
I think that in the past, how I've done it, I'll give it to you all to confer at your leisure.
Okay.
And here it is. That's the only evidence we have to tender at this time, Judge.
Okay. So you are resting, you're going to make argument, but we can now turn, after an extremely efficient presentation from Mr. Boring at the fresh air, to
Don't get used to it.
We won't.
He was making fun of me.
Oh, that's an easy target.
I just want to put on the record for the future. So when the Supremes look at this, I know we have in the commentary, it encourages us to stipulate the facts. And so I just want to make sure we are doing that in this.
And we do as well. And I said that only in jest. We appreciate very much that the 2 sides have come together. I don't know how it would have helped Judge Johnson to fight the facts in this case. His lawyers have made the decision on his behalf to stipulate and highlight that there may be at the edges differences of opinion, and you're welcome to focus on those, but the thrust of what occurred on that one evening, it doesn't sound like is in dispute. And so we all appreciate that. And it is consistent with that exhortation from the rules and the commentary, where if there are things not at issue, why fight over them? So that's great. I hope that spreads to other proceedings we have. Exhibits 1 and 2 are admitted, and the director has effectively rested. Mr. Kathy, you're up.
Can I
Again.
get some water some way? I gotta have some drink of water.
Sure. I don't know that we're the right folks to
I
get
know.
that for you. That's not for you. Thanks. I think the person distributing it didn't know who all should get it. Maybe you're representing.
Yeah, don't pick that up, Dennis.
Make it be some DNA for me on that. Well, at this time, we'll call Judge Johnson to the stand.
Okay.
Where do y'all wish him to sit? They have nameless.
The witness stand is up here. He'll be right near us. Just so you know, Jack. Like Jack. Yeah. Jack's has lots of questions.
Judge, raise your right hand, please. Swear the testimony you're about to give before this panel will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Have a seat. Identify yourself.
I'm Gerald William Johnson
And Mr. Johnson, where you live?
in Habersham County, 110 Fairview Court, Demorest, Georgia.
Tell the court a little bit about your background. Tell us your education and experience background.
Well, I don't really have a formal education. I graduated high school in 1988 from Habersham Central. I started a career in law enforcement in 1989 as a detention officer at the Habersham County Sheriff's Office and moved forward from there.
How many years did you spend in law enforcement?
From 89 to roughly my appointment as chief magistrate in Habersham County, which was in July of 2014. I've had extensive training in law enforcement, approximately 2,000 hours, I believe, and some of that involved some specialized training as far as my career in law enforcement went.
Judge Johnson, chief magistrate, does that mean there are other magistrates as well? And you preside over them, or there's only one and you get the title of chief?
Well, there's two of us.
Okay.
I'm the chief and I have an associate judge, Amy Thomas,
Okay.
who's actually been holding the fort.
Doing both jobs.
Yes, sir.
Judge, when did you become magistrate judge?
July, I want to say 15th or 16th of 2014.
Tell the court what the duties of a magistrate judge are, especially in Habersham County.
Well, we handle all the small claims cases under $15,000. We do all the criminal warrants, fugitive extradition hearings. We do writs of possession, dispossessory proceedings. I'm sure I'm leaving something out because I'm nervous sitting here.
You have small civil matters
Yes, sir.
and you have issue or non-issuance of warrants.
Correct.
And you have dispossessory proceedings, leases and things of that nature.
Yes, sir. And of course, we do the commitment hearings for defendants when they request them. Probable cause exploration for
What-
continued detention.
What educational continuing ed training have you had to prepare you for the magistrate?
Upon my appointment, the state requires that you attend a minimum 40-hour criminal training and 40-hour civil training to be a magistrate judge. And in addition to that, I've continued my judicial education, required 12 hours a year through the Institute of Continuing Judicial Education, ICJE, with the state of Georgia.
Have you done anything public service relating to domestic violence, domestic dispute, anything of that nature?
Well, in addition to my career in law enforcement, I was involved in our local Mountain Circuit Family Violence Task Force, and I was actually the chair of that for a year. I can't remember the exact year, and of course, I'd have attended conferences on family violence training. And one year, I think it was a couple of years ago, I actually got recognized for 25 years of service. So that was
25 years of service for what?
for my contributions to the family violence cause. Being involved in the circuit task force.
You received recognition for your long service in that task force.
Yes, sir.
What did the task force do?
Basically, it's public awareness, circulating information on how victims can reach out for assistance in cases where law enforcement interventions wasn't available or didn't do enough, just to make the resources and advocates through the circle of, through our advocacy centers available to anybody who wanted to reach out for help.
Do you understand the irony that's probably the court is considering right now in your background of family violence?
Yes, sir, I do. And I'm extremely embarrassed and ashamed and full of guilt that I'm here in front of this honorable panel and y'all over these horrible facts and circumstances.
What have you learned, if you've learned anything, between that event and today that might have contributed to your actions that evening?
Well, I mean, through all the extensive therapy, I guess I could sum it up by saying that self-awareness and the realization that substance use disorders can certainly affect your judgment and cause you to behave inappropriately and ultimately put a humongous dark spot on your career, past, present, and future.
Did you, on the day in question, you heard my statement, Mr. Boring's statement to the panel. Did you intentionally mean to draw down on Travis Gerald?
No, sir.
Tell us, Mr. Court, just exactly as best you remember. Or do you have trouble remembering exactly what happened?
I do have problems remembering the details. I remember what I was thinking more than actually what happened.
And tell the judge what you would tell the court, what you would think, and the panel what you would think.
For whatever reason, that incident with Travis Gerald's, I sit in our living room with my back to the wall, and I know that probably sounds somewhat irrational, but that's because of my law enforcement career. I often will put myself in a position where I can defend my house and my property. And where my chair is sitting, I can see the front door, I can see a portion of the dining room window, and the driveway kind of goes at an angle that way. And unfortunately, we really don't have a lot of close friends, and people don't just drop by my house and say, "Hey, how you doing?" Nobody just comes up to visit. Is one thing, and when law enforcement comes, because of the way I've implemented our online warrant system, they'll always text me or call me if they need to come by in person, so I know they're coming. I usually always know who's coming to the house. If somebody shows up unexpected, when I'm in my normal thought processes, I'm reluctant to admit this, but I always go to the door with a gun, but I don't always have a rifle in my hand. I've usually got a pistol behind my back, or I've got it stuck in the back of my waist, just so I'll have easy access to it. And mainly I do that, if I can elaborate on that.
Go ahead.
Is because during the course of my career, before I became chief magistrate, I was actually the chief investigator of the Raven County Sheriff's Office. And prior to that, I'd been in law enforcement and other somewhat supervisory capacities, but I've made some enemies over the years. And you know, sometimes people make idle threats, sometimes people don't say anything, but there's a couple of things that's happened over the years that really, really concern me. One was not directly related to my job, but it involved my job as chief investigator because the cabin that we have on Lake Hartwell was part of a seized, a government seizure, a drug situation that we had the opportunity, my wife and I, to purchase. And when we actually closed on that property, the gentleman that had the house prior to it being seized was heavily involved in a cartel, and he was also a prospect for a motorcycle gang. I know this sounds silly, but he was a prospect for a gang called the Outlaws. And when we closed on the house, when we walked into the living room, laying inside the fireplace was one of those publications called The Bad and Busted. And it was open to Rabun County and just laying there in the, because people were constantly breaking into the house while we were closing on it. And that paper was laying there. Well, I took that as a message to me that we know.
But have you received threats in the mail from people that you had to deal with in your law enforcement?
Not a direct threat, but one gentleman comes to mind. His name, I won't say his name, but he's a gentleman I arrested for elder abuse and some other, I forget what the other charges were, but anyway, he got a pretty substantial prison sentence.
Do you have closed circuit TV cameras in any of your properties?
Yes, sir.
And have you found prowlers around your property by the camera?
Yes, sir, I have.
All right. So when you opened the door, did you realize right away it was Travis?
What I recall, what I remember is watching Travis run. I saw him run back down the sidewalk towards the driveway, and it occurred to me that I had frightened him, and that was never my intention. I would never hurt a police officer, number one. Number two is that I didn't know who was at the door, and I did not even have any idea that I had pointed a gun at anyone until the sheriff came to talk to me a couple of days later, and he told me that I did, and I was like, because I couldn't believe that I'd actually pointed the gun at Travis, but
You have no,
I have no reason not to believe that.
yeah, you have no capacity to deny that you did that.
Right.
Okay. Now, let me lead you a little bit through this, if Your Honor will indulge me. When the police came, they didn't come because somebody had called them to your house, right?
I don't think so, no.
Yeah, Travis came out there to the general area where they heard gunfire. And he said, that's where Judge lives. Let's go up and see if he knows anything about the gunshot. Isn't that the way it came about?
That's what he told me. He said that he just stopped by to see if I had heard anything.
And that
He didn't know I
precipitated,
was the problem.
and that was him knocking on the door and using. Now, after he disarmed himself and he came in, he discussed what was going on with you and Laura, right?
My recollection is Laura was still in the bedroom.
Well, she eventually came out.
Yeah, yes.
And he left without making any charges against you, and actually said there were no charges, correct?
Well, we left together.
Okay. But he didn't just leave you there. What did he do with you?
Well, he wanted to take me to my mother's house, my 87-year-old mother,
How old?
87.
So wasn't Travis's idea was he would diffuse a situation by separating y'all and taking you to your mother's?
That's my understanding.
And isn't that what Laura wanted him to do?
Yes, sir.
Just get you out of the house.
Yes, sir.
Now, you went to your mother's and he dropped you off, right?
That's correct.
Then what happened?
Well,
Before you answer that, can you help us envision your neighborhood, if neighborhood is the right word? The closest house to you, is it 20 feet away? Could you not throw a baseball and get it into another neighbor's yard? How, I'm thinking suburban neighborhood where that you've got a fence and right on the other side of the fence is your next neighbor and next neighbor. But it's Habersham County in the way Mr. Cathy has described it. Maybe you had 150 acres. And so the next neighbor was almost in a different time zone.
no, sir, it was 2 acres. There's two lots. It is a subdivision, but we have 2 acres. The house is within, I'd say 30, well, I'm not good with distance, but it's not right on the roadway. And then the backyard is open area with wooded area surrounding that. So
If you're standing at the top of your driveway near the front of your house, can you see other houses?
yes,
Okay. And not just one, but it's a subdivision. They happen to be big lots. It sounds nice, but it's not that you're the only house for,
no, it's a residential area. Yes, sir.
It's rural residential, right?
Yes, sir.
You have 2 acres yourself, which is a pretty good sized lot for a house lot. All right, I think I was to where you had been dropped off at your mother's.
Yes, sir.
All right, so you're dropped off at your mother's, but you don't go on your mother's, do you?
No, and they absolutely the only reason I did not do that. And all, I mean, as irrational as this sounds, is again, my mother's 87 years old. She has a lot of health issues, but she's in really good shape. But I didn't want to upset her, but I grew up with my mother, who is of a Pentecostal belief system. And I don't know if y'all are familiar with that or not, but jail would have been light compared to what would have happened had I crossed that threshold and listened to the thrashing I'd received from my mother. I didn't want to upset her. I didn't want her to see her son in that condition because I was intoxicated, and I just did not want to expose her to that. So I didn't have my phone with me. I couldn't call somebody to come and get me. I couldn't do anything other than I thought, well, I'm just going to walk back to the house. And
How far is it?
gosh, it's a long ways. I regretted that decision because I think it's 8 to 10 miles, if I'm not badly mistaken.
Took you several hours to walk back home.
Yes, sir.
What had been going on at home during that 5 or 6 hours?
That I was walking.
Yeah, what was Laura doing? You've learned, you didn't know, but you've since learned what was going on.
You know, honestly, we really haven't talked in great detail about it. My understanding was that somebody called to make sure I made it to my mother's, and when I wouldn't, my mother didn't know I was on the property, number one. So when they called to see what I was doing or if I was there or whatever the case was, my mother said, he's not been here. And so my understanding was at that point, they thought I was wanting to hurt myself or something.
So for the next few hours while you're walking, your family, including your wife and your son, were looking for you to make sure you hadn't harmed yourself.
That's my understanding. Yes, sir.
Now, when you got back home, what was there?
I walked through the yard, walked up to the front door and went to walk in, and the door was locked. And if I remember correctly, I walked back out to my truck, and about that time, that's when 2 sheriff's cars pulled up in the yard, which scared me because I thought something else had happened, and they were responding to something else. I didn't know why they were there, because in my mind, I wouldn't do anything wrong.
Had they been called to participate in the welfare check for you?
That was my understanding, because they kept asking me, am I okay? Am I okay?
Now, any of the events that are in the complaint or that we've heard talk about, did any of those occur once you got back to the house?
No, sir. No, nothing happened.
Everything that went on, including your wife arguing, you may be breaking her windshield, all that disagreement went on before Travis ever got there.
Yes, sir.
So no other event of any kind happened after the Travis made his initial appearance there.
No, sir.
So what happened at the end of that evening?
My son ended up taking me back to my mother's, and I had to face the music with her. So that was
Was it as bad as you thought it was?
oh, it was worse, actually.
Now,
No, the shame and guilt was worse. Just my mother seeing me like that. She actually encouraged me to repent and change my ways and stop messing with alcohol, those kind of things that you'd expect a mother to say. But my mother loves me. She was very
let's
compassionate.
talk about your alcohol consumption. Did you ever drink during the daytime?
During this incident?
No, during day hours, when you were at work.
Oh,
During
no,
work
sir,
hours.
never. No, absolutely not.
Have you ever had anybody accuse you of drinking on the job or doing anything involving alcohol before this event
No, sir.
in your life?
No, sir.
Had your alcohol drinking consumption grown, continued to increase?
Yes.
You have a reason for that?
Other than poor choices and, during and I'm not blaming this on anything. I'm accepting full responsibility for my bad behavior, but during the pandemic, it was easier to isolate, easier to work my schedule around drinking. But I made very careful to make sure that I didn't drink and drive. I wouldn't, if I knew I had to go somewhere, I wouldn't drink. I'd work my schedule around that. I didn't drink before I went to work. I drank when I came home, oftentimes, but if there was something else going on, I never incorporated that into my normal activities.
Did you even drink in the public?
No, sir. No, I never did. As well, especially since when I was appointed as judge, I didn't want the appearance of impropriety. Somebody say, "Oh, there's the judge over there drinking," or whatever. Even though I was drinking in private, I never let anybody see that. Nobody even knew that I drank, I don't think, for the most part.
So that would mean that Mr. Kathy's helping us understand it's a different community, but if you went to a restaurant in Clarksville, wouldn't have a glass of wine or a beer there, you would have water, because that's public in your mind.
Maybe not water, but no alcohol.
Okay, Coke, whatever. You have a soda, but not a beer or a glass of
No,
wine.
sir. Never.
Wouldn't go to a bar.
No.
So the alcohol we're going to hear about over the course of today that you consumed was always at your private residence or a cabin, but your private space.
Yes, sir.
Now, when you awoke the next day, when was your next interface with the law enforcement authorities?
I'm sorry.
When did you next hear from the police or the sheriff's office or even the JQC? Who was the first person you heard about that said, let's talk about the events of that evening?
I think Wednesday I went to work, and then Thursday I was at work in my office when the sheriff walked in, and he started talking to me about the incident and telling me I needed to do.
Joey Terrell.
Yes, sir.
And what Joey tell you?
Well, Joey, it was kind of interesting because Joey, he's a monster of a man. He's probably over 7 feet tall, I think. And he came walking in and he told me he loved me, which had really caught me by surprise. Just the fact that he articulated that. And then he sat down beside my desk and he says, you got a problem. And I agreed with him. And he says, you know what the first step in solving a problem is, don't you? I said, I shook my head, agreed with him again. He says, if I remember correctly, he said he was my friend. He says, but that he called the JQC. And I told him, I said, well, I understand. I expect that. And then from there, he told me that he gave me a couple of therapists that some of his department uses. And one of them was Miss Brewer. I'm sorry, I keep hitting that. One of them was Miss Brewer. And that's one of the ones I set up an appointment with that day to go talk to.
How long after that did the JQC investigators come and see you?
It was the following week, I believe.
Did Sheriff Terrell tell you he was going to call the JQC?
He told me he had already called them and that they had started an inquiry or investigation. I forget the words he used. Then right after that, Judge Smith called me, and
that's our Superior Court judge, right?
yes, sir. And he essentially said that there's an underlying issue or something, like, because apparently he knew some of the facts and circumstances surrounding that, and that the day in question. And he said there's an underlying issue that I need to address. And he kept asking me if I was okay. Excuse me, if I was okay. And I reassured him I'm okay. But really I wasn't okay. As far as I knew the hole I'd dug for myself.
When you were saying that you were okay, were you at that time remembering enough about what happened on October 18th? Or how did that unfold? I'm still not clear as to whether you learned more about what happened that night because the sheriff told you, he pulled a gun on one of my deputies and There's this broken windshield, et cetera. In other words, other people pieced it together for you, or if by the time Judge Smith is calling you, you had begun to reconstruct that evening to realize, and I trust we're going to get to this, this was a very different evening from other nights when you had been drinking.
Most of what I recall is very limited, but the people that told me about what happened, I had no reason not to believe them. So I accepted that as fact, even though I don't really recall it.
Many of those conversations were also with your wife, who helped you reconstruct the events of the last few days. Isn't that
Yes, sir.
correct?
Yeah, she told me some.
And it was about that time that Laura herself committed to a life of sobriety. Is that correct?
That's correct. Yes,
She's been like you, sober since October.
yes, sir.
Now, I believe I told the panel that on October 26th, you met with the JQC.
Yes, sir. That's
Right.
correct.
Y'all are,
Was that with the panel or with?
it was investigators, I think Mr. Gosart and Pro Hoc investigator, Mr. Davis.
Yes, that's
Is that
correct.
right?
Those two, yes.
Now, Your Honor, I have, I've shown to Chuck, just so y'all can follow this. Gerald's prepared a timeline of his recovery, and I think it might be instructive for y'all to follow that.
Is it an exhibit?
It is an exhibit now, Your Honor. It's not in my package
Okay.
because I only saw it, I'd had it as counsel from Gerald and I,
I don't object.
and Chuck, I showed to Chuck. It's just
Okay.
shortening things, if I may.
So
What exhibit number we're up to?
we'll be on 13, and should we, just so the record is clear, do you want to tender 1 through 12, which you already gave us, and then 13, which you're handing us now? Mr. Boring, any objection to Judge Johnson's exhibits 1 through 13?
No objection.
Okay, they're all admitted.
I have a question. You mentioned your wife.
Yes,
You mentioned your mom. I'm from Copper Hill, so I'm slow. Is your wife or mother 99 years old?
no, my mother's 80.
Because the police report says whoever Laura Johnson is was born in 1899.
Laura Johnson is in court, Your Honor. You can judge for yourself. If she's 99, I need to eat, I need to take some of what she's
Just going
taking.
by what the police wrote.
I know. Well, Your Honor, this goes back to when we admitted all the allegations. It's things like this that are incorrect, but they don't matter. This is the nature of those kind of
I
things.
said I was slow. It's just confusing because you mentioned both of them.
Well,
I'm impressed you did the math.
Ms. Johnson is in court with us today and a little short of 99. Now, Judge Johnson, I have provided the panel the timeline you provided me about your efforts at rehabilitation, what you've done since, and I don't expect you to go through each and every one of them in detail, but using this to refresh your memory, tell us about your recovery.
I think the biggest step, other than meeting with Miss Brewer, who was trying to, he was very empathetic with, because I mean, I was a wreck. I realized that I was in a mess, physically, emotionally, spiritually. And she suggested that, you know, an inpatient treatment might be a good option for me. And she was very delicate about the way she approached that, because it took me, to be honest with you gentlemen and everyone here, that it took me a good several weeks to come to grips with the fact that I may be an alcoholic, which now I understand I am. But that was the pivotal moment to get into the treatment, because I went into the 35-day treatment with the idea that, hey, this may help me keep my job. After I got into the 35-day treatment program, I realized that I had a problem and I needed to get some.
Became more than just a token way to keep your job.
That's correct.
Would you say that program was effective in letting you know, understand the nuances of alcoholism, the dangers it can have?
Absolutely. I had no idea that how dangerous it was when you just try to quit drinking, when you have that kind of tolerance. Yes, sir.
How much? And what were you drinking?
Bourbon and the frequency was that I drank more on the weekends, and usually, and during the course of the pandemic, I got to where I was drinking maybe between 5 to 8 ounces in the evenings, like before I went to sleep. And I would probably go through a whole bottle over the weekends, just, I mean, not every weekend, but just depending, I didn't really have a particular threshold. It's just if I drank, I drank, and if I didn't, I didn't, unless of course I was going somewhere or something like that. But no, my tolerance was so high, and that's the, if I can touch on this a little bit. And I'm so embarrassed to say this, excuse me, but I could function. I could have a conversation. I could take care of business. I had my wits about me under normal circumstances all the time, except for right before bedtime. And I thought the alcohol was helping me sleep, because I had trouble with not sleeping very much. I was only getting I'm not asking for sympathy. I'm just telling you what was going on. I was only getting 3 or 4 hours of sleep per night. And I'd have the worst nightmares ever. And I thought the alcohol was helping me to sleep, which I found out through treatment that it's actually made it worse. And which really.
Judge, I think probably because your background in law enforcement and judicial career, that you thought you knew something about alcoholism, didn't you?
I thought I did. I could actually do the math when, as far as when I was a patrolman, we had to do the path of alcohol. When you do the intoximeter, there used to be a 3,000 where you had to memorize all that. And the rate of alcohol dissipates at a rate of 0.015 per hour, according to
I'm more addressing the disease of alcoholism. You thought you knew something about it. You didn't, did you?
Oh, no, not what I know now. No, sir.
Okay.
Is there something, you said that you had a high tolerance. What was different about October 18th? Why did you reach a point of immigration of this?
Well, that's the part that I really am extremely embarrassed about, and it's difficult to articulate to you. But just to be honest, and it's like I told, I think Mr. Boring in a phone conversation, I left this part out of our JQC inquiry, investigator inquiry, because it is so embarrassing to me. But Monday morning, I just came to the conclusion I was going to shoot myself. And I didn't.
The 18th is, I'm sorry to interrupt, but the 18th is where in relation to Monday? That is
Monday.
Okay, we're talking about now the same day.
That's correct.
12 hours.
That's correct. So in the wee hours of the morning at 3 o'clock, I made the decision, well, between 3 and 4. That's when I always woke up. I thought, you know what? I'm just going to do this. But the challenge that I ran into, and I'm glad now, the challenge I ran into is I didn't have the courage to pull the trigger. So I wrestled with that. And then I thought, well, I'm going to go to my old go-to, and I'm going to drink until I get the courage to pull the trigger and end this. And unfortunately, I guess because of my tolerance, I kept drinking, and never. I don't remember any of that, putting the gun to my head or any of that stuff. I just know what I was thinking. And I was sitting in my chair before I actually shot the gun outside on the back porch. I was sitting in my chair, and as I was fixing to shoot myself, I thought, you know what? I got to do something. I got to leave a note or something, because they're going to think my wife murdered me, because nobody's going to expect this from me. They're not going to think that nobody knew what I was wrestling with personally. And so I thought, well, I'm going to leave a note. I did this to myself. Don't arrest Laura for whatever reason, or, put her through some horrendous investigation, and that this is self-inflicted. And as I was sitting there writing, if I can elaborate on that a little bit.
You're answering the court's question, so you can.
Keep going, please.
As I was sitting there writing, that, I'm intending, I don't remember exactly what I wrote. I just remember I had the pad in my hand and I was writing all this out, that this is self-inflicted. And because I know as an investigator, suspicious death, you always look at the spouse first, that they might have had something to do with it. Or I don't say always as a training issue, but I mean, that thought is always in an investigator's mind when there's some suspicious set of circumstances, when there's only those two people in the residence. But so I wanted to clarify that, but in doing that, and I mean, this is the absolute truth. I had the door open there at the back of the house because I was going to shoot myself outside. And there was two dogs in the distance were barking like back and forth at each other. And simultaneously I could hear a vehicle laying drags, which I later observed the black marks down the road, and just all this noise. And, you know, with whatever irrational thought processes, I stepped out on the porch and discharged my rifle 9 times into the ground. That's the chatter that they're referring to. My wife was in the bedroom with our dogs. There was nothing going on between she and I, just all this noise. So I went out there, did what I did, come back in and sat down. And somewhere after that, I remember Travis coming to the door and watching him run from me. And it really, really made me feel horrible because I think the world of Travis. He's a great person. He's a great professional. And I scared him. And that bothered me. That bothered me.
The first officer.
Yes.
Lieutenant.
Yeah, he was the only officer that responded at that time. He was alone, as I remember. And I remember talking to him, but I don't remember what we said. I do remember not wanting to be video because I think they all have little body mics and everything now, and which I don't know if he had one on or not. And I remember I was concerned about the video because I was intoxicated. I didn't want a video floating around of me intoxicated because I've went to such great lengths to ever avoid anybody ever even knowing that, if possible, that I consumed alcohol. But that was what was going on that Monday morning, and I drank more, and my specific intent was to get the courage to shoot myself.
Well, let's walk through. When did you realize, or have you, that suicide was not going to be Gerald Johnson's answer?
Well, I think I really came to that conclusion on the walk home, because from Monday night, the walk from my mother's residence to our residence.
And I assume that was reinforced with your therapy?
Yes, sir.
Did you discuss with any of your therapists your time in your life when you did have suicidal ideation?
I'm sure I did. I mean, I'm pretty transparent when it comes to that kind of stuff.
Let's use your sheet and walk through with the panel some of the things that you've done in order to return yourself to wellness.
Well, like I say, that Miss Brewer, that reaching the conclusion that going to the inpatient treatment, that was pivotal because I was still in denial, I think, at that point. But while I was a patient at Blue Ridge Mountain Recovery Center during that 35 days, I came to the realization that, yeah, I really did have a problem, and much to my shame. So after that, you know, their suggestion to me to continue my recovery was to attend a 12-week outpatient treatment, which that happened on December the 15th. And all this stuff kind of happened consecutively to each other. So I started that in December the 15th and simultaneously started doing what they call it a 90 and 90. It's 90 days of Alcoholics Anonymous meetings consecutive in a row, 90 days of AA meetings. So I told them I'd do that. And even though I didn't, at that time, I kind of felt like I didn't need to, but the more I got involved in it, I realized that it really was helpful, because you got to have something to take up that time where you'd spent all that time in the past planning your drinks and your schedule. So the 90-90 worked out real well. I actually went to more meetings than that because one of the AA suggestions is that you get a sponsor. So I wanted to go to one of our local AA meetings to try to come up with a sponsor to help me work what they call the 12 steps. I don't know. I guess I'm kind of assuming everybody knows what that is, but prior to this, I didn't know what 12-step programs were or any of that stuff. So a sponsor will help you work these 12 steps for your continued recovery. And the theory behind that is that a person, rarely have they seen a person fail who thoroughly follows those steps. So I made a commitment to thoroughly follow those steps, and that's what I've been doing up to.
Now, you know how long you've been sober?
Yes, sir. November the 10th was the night before November the 10th. I had taken my last drink. Now, prior to that, when I was, let me clarify one other thing too, because there was something that I told the JQC investigators that I had to go back on. I told them, I said, I have not drank anything since the incident. That was between the 18th and the 26th. And in all honesty, when I called Blue Ridge Mountain Recovery, they weren't going to treat me because they said you have to be involved in active addiction. So I thought about that for a moment, and I thought, well, I'll call you right back. So I went, had a few drinks, and then I called them. I said, all right, now what? Now, I'm not making light of it, but I mean, that's what happened.
You punched your ticket by having a drink.
Yes, sir.
So, you've had a year of sobriety.
Yes, sir.
Holding off the wagon any?
No, sir.
Wife mirrored you?
Yes,
She
sir.
had been sober that long?
Yes, sir.
Tell me what that period of time has done, first of all, in your relationship with your family.
Well, my mother's, outside of my wife, that's the other important lady in my life. She's thrilled to death, and she's told me she didn't mind if I worked at the chicken plant as long as I'm stayed good and not to be derogatory towards a manufacturing plant. But anyway,
Nothing wrong working chicken.
exactly. But you know, she don't care what I do as long as I'm good and do what God wants me to do.
Important. How about with your wife? Well,
Oh, it's almost like we're dating again. It's when the silly arguments and the silly stuff that used to be an issue with us is it's just that it's embarrassing to look back on the things that created friction in our relationship to where we're at now, where we laugh a lot. I mean, we really are enjoying each other's company, and without alcohol, it's pretty amazing. I wish we'd done this long before all this mess happened.
I know you talked a lot about you want this panel to recommend to the Supreme Court that you return to your job on the bench, right?
Yes, sir, I do. I'd love to go back to work.
And tell us why. Why would you love to go back?
Well, I mean, well, the honest answer is I love my job and I love serving the public and I love working with people, but I really feel like there's some stuff I can bring back to the table that will make a huge difference in people's lives. And one in particular is that, and it may be because of my background in law enforcement, I always had a tendency to look at things kind of black and white, and much like the way Mr. Boring presented his case this morning, that's kind of the way I thought, they committed a crime or these elements exist and they're going to have to suffer these consequences. But after being in detox for a week, and just seeing some of the folks, and I'll bring this all together, I promise. Seeing folks in detox that were suffering, with the other substances like fentanyl and heroin and things like that, and then watching them go through that process of getting sober, and then realizing that they were really sweet, wonderful, intelligent people. Now they were horrible prior to, they tell stories about stealing from this one and doing that. But after they got the substance out of the equation and seeing what kind of wonderful people were and well educated too, that's what really shocked me. In the past, when I think of a heroin addict or pardon the expression, or a junkie or something like that, I think of just bad element, crime, criminal. These are not bad people. Now, I'm sure some of them are, but a lot of them, most of the people I was in there with were really wonderful folks. And taking that human element and applying that to my job and trying to offer at least a pathway to recovery. And what I mean by that is that, during this time, I've been trying to think what I could do to change the way I do business, because oftentimes the magistrate judge is the one that sees the people first that's been incarcerated. They're setting their bonds and telling them what they've been charged with, telling them what their rights are, talking about appointed counsel versus hired counsel, all that stuff. But in addition to that, I always impose special conditions on their bond, which one of those is if it's an alcohol related, I mean, it's almost like a checklist thing. If it's an alcohol related offense, I'll say don't drink. If it's a drug related offense, I'll say don't do drugs, which in reality, that for an alcoholic or a serious substance abuse situation where they've got a dependence, that could be a death sentence. And I didn't know that. I didn't know that I was at risk for dying. When they told me that when I went into rehab, saying that, we're going to have to keep a close eye on you. We're going to monitor this, monitor that. We're going to give you some medication. I thought, why? It's alcohol. And they're like, yeah, apparently alcohol is probably one of the worst substances when you reach the tolerance level that I had gotten to. So, and then I looked back and I thought about, my goodness, if people follow my bond conditions to the letter of the law and, don't drink when they've got a real substance abuse disorder and probably need some kind of medical detoxification, they could die. I don't want that on my conscience. I thought I was doing the right thing by just saying, don't drink. But one of the things I want to implement is if I'm given the opportunity to go back, and even if I'm not given the opportunity to go back, I want to share this with my associate or whoever takes my place, a 50-minute presentation on the fundamentals of substance abuse disorders, whether it be alcohol or whatever their drug of choice is. Basically, according to the DSM-5, the Diagnostic Statistical Manual for the Mental Health Issues, there's a question and answer process that you can go through yourself that covers issues of tolerance, withdrawal, whether the user is using larger amounts, longer periods, inability to cut down or control the use, increased time spent obtaining, using, or recovering, craving, and compulsion. There's 11 of them. And essentially, what my intentions are is during this fundamental, make it a part of their bond conditions that they have to attend this fundamentals of substance abuse. And during that process, ask them to ask themselves, if you have 1 to 3 of these symptoms, then you may have a mild substance abuse disorder. If you have more than 3, you may have a moderate substance abuse disorder. If you have, the whole gamut, then you may have a severe disorder. And then once they're thinking about it, the key to recovery is a willingness. You got to be willing to.
How can you assure this panel that you won't drink again? What assurances can you give?
I can give you my word. I can certainly, but I've never lied to anybody during this whole thing. I feel like my credibility as far as my word goes is still worth something, even though I've got all this other mess.
Sometimes when people are restored after suspension, some conditions can be placed upon them. For instance, alcohol, random alcohol. Willing to do that?
Oh, yes, sir.
Sometimes conditions like a mandatory visit with a therapist are important.
Yes, sir. There's got to be consequences. I mean, because of the nature of this, why we're here.
Here's my struggle. Is a struggle. Had judges since 2004, since I've been full guns in court, not alcohol related. Judges have vehicular homicides before they were a judge. One of my best friends and one of the best judges this state has is an alcoholic. Dealt with that. We've never dealt with alcohol in a weapon. My struggle is we have to be proportionate. The judge that pulled the gun in court, he's gone. We've had judges with DUIs in this courthouse, and they served a punishment. They were sanctioned. They went back on the bench. But they didn't pull guns. The struggle I have is, what do I tell the post commander in Tacoma, who, if a slip sleeve trooper had done this exact same conduct, might not have been handled with anything other than dismissal, prosecution, and research. So my struggle is coming up with a sanction that is proportional but also humane, and I don't know what that is yet. So
what would you do? What sanction is appropriate in your mind?
That's a wonderful, excellent question, because I'm really not sure, because I'm kind of throwing myself at y'all's mercy with the intentions of trying to go back. And it's a terrible predicament I put y'all in, and I realize that. And for that, I do apologize. You know, with the case-specific set of circumstances with me pointing a gun at a law enforcement officer, I would never, ever, ever do that intentionally. When I went to the door with a gun, for whatever reason, irrational thought processes, I felt that there was a potential threat outside of my residence. And once I dispelled that threat, I dropped the gun. I don't recall pointing the gun at him. And the only thing I can try to rationalize it to make myself feel better about the situation is when I snatched the door open. It was a long gun, but and the way I'm not making light of the situation at all, so please don't misunderstand what I'm saying, but every time I've ever breached a door, every time I've ever executed a high-risk warrant, every time I've ever committed a felony stop, if I've got that weapon in my hand, the barrel is looking where my eyes are. So I'm identifying threats or dispelling threats. And once that threat is dispelled, then the weapon is.
I understand all that. I'm looking for help on what do we do now.
Well, I think if it were what I would be wrestling with if I was in your position is that, did I intend to point a gun at a police officer, which I did not, but it happened. So, you know, I don't know. I don't know what's available to the JQC as far as disciplinary action. I know I've heard of public reprimands and things like that, but I don't know that would, I don't know. It's a difficult position. And
A reprimand right now is not something I would throw out if I were you.
You asking?
More
You asked
questions. What have you been doing with you over the past year? Clearly treatment, I got that, but have you been working in some other capacity, or what have you been doing?
Well, yes, sir. In March, along about the same, I was thinking that, well, actually I almost resigned in March because the pressure was really, really intense. You know, there was articles coming out frequently in the Northeast Georgian that was really, really weighing heavy on me. And I think it was long about that time that one of the articles says the county deserves better, which I absolutely agree with that statement. And all I can offer is a better version of myself. But what I did is I told my wife, I said, I can't stand just waiting around, listening for the phone to ring or waiting for Dennis or Adam to say, hey, we've done this or we've done that. So I actually applied at a manufacturing plant. And I thought that would be a wonderful fit for me because they wouldn't do an extensive background check. I didn't go in saying, hey, I'm former chief investigator, current judge, I'm your man to do this. I got a low-level assembly line job. And it was actually kind of rewarding in the sense that nobody knew who I was. Not that I am anybody, but I was just one of the guys. So I was, for the last several months, I've been working at an assembly plant. And I actually got crane certified. So I lift engines and transmissions that go in these little buggies. But anyway, that's
Judge, what shift do you work? What shift you been working?
night shift.
Work night shift.
Yes, sir.
So your day is tied up with work and sleep, kind of that occupies your day.
Yes, sir. Yeah, and one of the reasons that I chose the night shift too is I'm continuing to do the AA and continuing to study and read and working diligently on my sobriety. But there's a AA publication called Living Sober, and one of their suggestions is that you find something to fill that void, you know, because most of the time I drink in the evenings and on the weekends. So during that prime drinking time, I was working my tail off, pardon the expression, at this assembly line plant.
Judge, if I can ask you, while you were at Twin Lakes or the Twin Lakes Recovery in Gainesville, Here it indicates that you were receiving random drug tests. Is that correct?
Yes, sir.
And can you tell me about those? How often were they and were they observed or not observed screens?
The, during the 12 weeks, I think I was tested every couple of weeks. And it was a urine sample and it detected substances in addition to alcohol.
Correct.
And
Did someone watch while you?
they didn't actually watch me go, but once the test was complete, I came straight out.
And have you been drug tested since that facility?
I was drug tested when I got hired at the assembly plant.
One time?
Oh, yeah, just that one time.
Ask you.
No, it's fine.
If we urine screened you today, would it come back negative?
Negative, yes, sir. Yeah, I promise you, again, my credibility is, I've never lied to any of these folks or anybody. I've not lied to my attorneys, not lied to my wife. I'm not lying to you. I've not taken a drink of alcohol. Matter of fact, I had a prescription for tramadol, and I asked my doctor not to prescribe that to me anymore because I didn't want anything remotely, which tramadol I think is a low level pain reliever or whatever. I didn't want anything in my system. I take Tylenol, that's it, and relief.
Thank you.
Judge, another element that we're wrestling with is how you were treated by local law enforcement and whether that treatment was different because of who you were. And I'm curious, you have to speculate in answering this. If you had been Fred Jones, local curmudgeon, not known to law enforcement, not loved by or respected by law enforcement, and they came knocking on Fred Jones's door because there had been gunfire in the neighborhood, and you answered the door with the sights at Lieutenant Terrell, wouldn't you have been arrested, if not shot?
That's another excellent question because the only thing I can say, and if you don't mind me speculating, is that
You need to.
there's been other cases where our sheriff is a firm believer in the castle doctrine. I mean, he's not anti-gun, he's not and I probably shouldn't speak for him. It has the appearance of being not anti-gun, and Habersham County.
Anybody that knows Joey Terrell knows he's gold standard for sheriffs in this state. Finest sheriffs in the country. The struggle we have is we have to protect the appearance. We're the appearance police. And we have to explain to the public. The public has to have that's the struggle we have.
And you're in, while you have to speculate, you're actually in I think, a pretty good space to answer that question, that hypothetical, because you were in law enforcement for so long. And so if you put yourself in the lieutenant's boots and we're knocking on that door, I know this is the judge's house, so I'm actually expecting he'll say, hey, come on in or something, point a rifle at me, but a stranger's house, but you're entitled to do. It's not a crime to knock on someone's front door, not a crime to defend your castle. But if it had played out the way your event played out, and you were the law enforcement officer and this stranger did what you've been told you do, you don't recall a lot of it. How should that have gone in terms of the sheriff deciding, you know what, Judge, you've got some issues. I called the JQC. I'm gonna leave it at that. Versus you're just John Q. Public who pointed an assault rifle at a lieutenant, scared him enough he ran to the cover of his car. And in the end, he's like, you know what? This is just, I'm gonna make sure I take you over to your mom's house. That just seems like a different resolution than some we know we read about, where the person who pulled out the gun doesn't walk away from the situation, carried away in a body bag. And then probably the more mainstream approach, which is when all the dust settles, you're at least led away in handcuffs.
Right. And I understand that. The only thing is, as you're asking the question, I can tell you from my personal experience what I've done as a police officer. There's been times when I've arrested people that's pointed guns at me. There's been times that I've said, hey, put that away. And the times when I've asked them to put it away is when I showed up, and I'm not candy coating my situation, for probable cause, in my opinion, is in perception. It's, does he believe the facts and circumstances violate the law? And, I can't answer for Travis what he was thinking. All I know is that I scared him. I've had people pull guns on me when I've knocked on their door in the middle of the night as a deputy sheriff or as an investigator. And one that comes to mind, I didn't actually see the gun. I heard it, the hammer. And I said, hey, sheriff's office, hold on, and put the gun away. He's like, what do you want? I'm like, hey, I'm just here to ask you a few questions, whatever the case was. I don't remember when I was doing that. There was another time that we were doing an investigation where a gentleman, I was in the yard looking for stolen property. It was dark, and he come out of the shadows and was bearing down on me with a rifle. I didn't know he was there. He didn't know who I was. And I said, hey, whoa, I said, put the gun up. I'm the deputy. Well, he lowered his weapon. I didn't arrest that guy.
Sure.
So under those, if it had been the other way around, no, I would not have arrested me, regardless if I was the judge or whatever, because of the intent. I wasn't going to hurt him. I wasn't going to hurt anybody. I thought somebody was going to hurt me. The second thing would be, well, I mean, that's the crux of that. I would not have arrested me. And I want to touch on this just a minute. I think I told Mr. Davis and Mr. Gosart when they were interviewing me, and I told Travis a few days later, I thanked him for not shooting me. One of the things that I was also a police instructor, general instructor for a little while. And one of the things I taught was deadly force. But a lot of times before we go to the firing range, well, the courts are not allowed the courts don't have the ability of hindsight when it comes to deadly force situations, because if a person has the opportunity, the ability, and that person feels in jeopardy, then they're justified in using deadly force. Now, he didn't know I wasn't going to hurt him. And that was the key. He didn't know that. And if he had shot me, even though I wouldn't have shot him, I certainly don't want him to shoot me for a couple of reasons. I don't want to be dead. Number one, he don't need that on his conscience that he killed the judge or Gerald or whatever. I mean, we've been friends for years, but knowing that, that's why I said, all the elements were there. You could have dropped the hammer on me, figuratively speaking. He could have shot me, but he didn't. And for that, I appreciate it. I thank you.
Given all of that, help us out. What do you think the appropriate sanction from this commission should be?
Well, I mean, y'all don't have the ability of some type of probation type sentence, I don't
We've
think.
got all kind of abilities that we.
Yeah, don't worry about our abilities. If you were fashioning something, what would it look
I
like?
would probably fashion some type of taking and given the totality of the circumstances, some type of probated sentence where I have to report or have some kind of accountability. And as far as the bad acts themselves, I mean, I honestly feel like I've been publicly reprimanded because this has got a lot of publicity in our local newspaper, which it should be because I'm a public official. Yes, sir. I mean,
I missed that, Mr. Hyde. What'd you say? I missed that.
Public employee. That's a job.
yeah, no, I'm not criticizing them. I'm saying I've kind of been publicly reprimanded indirectly through the excellent reporting that Mr. Osborne has done in the newspaper. I don't have any qualms with that because I'm an elected official and I disappeared for X amount of time.
So you're saying some kind of probation and drug testing.
Drug, alcohol testing.
What
Well,
do I-
alcohol is my,
What do I tell the judge that pulled the gun in the courtroom that we ran off the next time I run in?
I,
He's no longer the judge.
Mr. Hyde, didn't that judge voluntarily give up his role?
I don't know that. I don't know.
I think I do. And I think you tell the judge, maybe he didn't have a good reason for pulling the gun. And maybe he wasn't in the privacy of his own home with a stranger at the door.
Right.
And he was not doing something legal. He pulled a gun in a public courtroom. It's a little different.
I'm very familiar with the judge you're talking about.
It's different to you and me. I don't know.
Well, it's different to, I think, an objective watcher of it. And that's what you are. That's what your position entails.
But I understand what you're saying.
Uh, Judge, McBurney, I asked you the question of, would this have happened to Fred Smith, with the implication that maybe something else would have happened? Tell me who your wife works for.
George Christian.
She works for the Mountain Circuit District Attorney's Office, right?
Yes, sir.
And lest anybody say there was any cover-up, Sheriff Terrell called, or George Christian, our local DA, called the Attorney General and said, would you appoint a DA from out of the circuit to investigate this case? Did he not?
Yes, sir.
And he appointed Lee Dara, the DA in Hall County, to look into this.
That's my understanding. Yes, sir.
Have any criminal charges flowed from that after the year that he's been looking at it?
No, sir.
So we just had testimony from that this is the best top-notch sheriff, top-notch deputies, top-notch captain. The DA sends it out. The JQC comes, we're open to him. I don't think it can follow that somebody got favorable treatment here.
So you're not making an argument right now. You're asking questions of this witness.
A question mark.
All right. And you have him on direct exam.
I do.
Okay. And while we just had that momentary interruption, it's high noon. And we don't need to stop right now unless you say, I've got 3 more hours.
It's a good time for me to stop, consult with my counsel and see if there's anything. We're very near the end, but I think it'll be productive if we talk a little bit during lunch break.
Okay, Mr.
I
Boring.
think it'll result in me shortening it rather than rambling and dwelling.
Okay, I want to remind folks of their commitment to be done by 5-ish today. So if we were to break for lunch now and reconvene a little after 1, is that making 5 o'clock unrealistically aspirational?
Still viable, Your Honor.
The viable is,
Aspirational, but one's goals must exceed his grasp, you know?
viable is the one word to use. Realistic?
Realistic is actual, accurate, Your Honor.
Okay, Mr. Boring, you
I
agree?
believe to a
or-
reasonable degree, we'll be out of here before 5 o'clock.
From my standpoint, I agree. I have no control over Mr. Kathy, unfortunately.
Okay, all right. Then let's break for lunch. Let's try to start up as close to 1 as we can make it, although we learned from our week here before, you can't really get to lunch, be served and eat it and be back in an hour. So we'll say 1:15, and we'll do our best to be back and re-energized by whatever meal we find. Thank you.
We're gonna remain unlocked. Oh, I was gonna leave my stuff. If it's unlocked, I may just come back in here, but. I assume you would. Okay, great, thank you.
Okay. Watch it.
Anyway. Right. Good to see you. Yeah. Hey, Dennis. How are you?
Hey, what's your name?
Good to see you. I watched a little bit and I brought you that water. Hey,
Next page from the DA's office.
Stole one, but I probably need another, but.
Stacy.
Everything. I'll come back to that. in a second. I stopped by Scott Smith's on some way down. So like, a lot of these guys down here. I said, I don't come. That's why. So I don't have a problem with it. Anderson County has 7 city courts. So, and we have major highway coming through. All of these line towns. So
We got a major 4-lane highway,
yeah.
and everybody does 85.
We got Clayton, we got all these restaurants that's come in, people traveling to the lake. So I do 10, 15
Cherokee.
a week. Yes.
She can hunker down in that,
And I put that strap.
she can hunker down in that courthouse.
Yeah. Anderson. Eloise.
Okay,
Yeah, Tuesday. He's still in his voice.
yeah.
It's hard to play one-on-one though. Different technique. I don't think so. I may find the ball.
I'll tell you what I was thinking.
Oh my God. He would get out unlocked.
It can just crumble up.
I think suspension. Kind of what we all. Good or bad, was. That's what. I think what makes it pretty good.
So, no, I.
Oh, me, no. Just had, water in the bag, you let me hit up.
Yeah, it was a barn.
No,
I had one in the office, ready to go this morning, left it there.
as long as I get breakfast, the rest of the day don't matter to me. I can survive through the rest of breakfast.
No, I got before this morning, so I'm good. What is that?
You all want to go get something? Take a break. Walk around a minute.
I usually do too, if I remember.
That's it.
Oh, yeah, hold on one second.
You just got it out. horrible sound this minute.
That's where he's judge now, that's where he worked a little while, was that, Buck Levens, the judge over in the other circuit. I think he might have been down there before he got appointed judge. Yeah.
Maybe the court has.
I figured if you were going by a timeline, I was anticipating you're almost done.
Yeah. So we're gonna.
You've gotten to the recovery part. All right.
We're going over the time. If you get locked out, everybody's getting locked out, we can't let them off. What you put in other than, what were you two exhibits, the stipulation? Charges?
the- Dash cam, the video, audio,
Oh,
from
yeah.
the car, and then the stipulations.
You put in the first video.
Audio recording.
Yeah. No, they'll stipulate the facts, no. I mean, unless, I guess it depends on cross, if I need to call investigator Gossard, I don't anticipate it.
I give that to you. It was laid on top of the copy that you had. I had a copy and I sent away right.
If you got a recommendation where I might be to get this copy.
If I'm setting up camp in the DA's office like the last trial, I would,
Works off the same time.
you know, you may check the cop bar on the left there, there's like the cop bar association offices there, you may ask them if they, no problem.
Get out of here.
really nice.
Courtney went somewhere, so.
You turn down.
Hey, I would rather just have the protein bar. I ain't gonna eat half much. What you need?
Our consent. Offers of settlement are not relevant usually.
No, no.
He was asked what. Not be here.
But you can, yeah, I mean, if you want to argue that, great. Yeah,
It's already in front of him.
Mhm. I think you've already talked to him about it.
Yeah, it's
I don't know. No idea. Taking pictures.
I caught that picture of me earlier.
I would have to say, I have not seen Rule 22.
I'm not either, and there's even a sign on the door reminding them.
Is that this? Is that the Northwest Georgia guy? I got I'm calling it with him too.
I'm trying to avoid
Yeah.
the newspapers.
That's what I know. Like, I didn't call him back. He called me and I was like, I wasn't gonna talk to him over this anyway.
Yeah.
I didn't call him back within like an hour and he just starts, JQC won't respond. I'm like, did you bother reading our rules? Like, anyway.
Yeah. And I don't.
Isn't that correct, though? You're not supposed to talk.
No, okay. I have, in this case, I have specific authority under our rules and talking about our investigative panel to contact other law enforcement. Which I'll talk to George, and I talk to, obviously, sheriff, but there was a witness they called. Trying to think of who else. Maybe that's about it. Actually, you're not, I mean, I wouldn't either if I were you, but technically you all aren't necessarily bound by it. It's within the agency we can. But I mean, why would you want to do that? He's made me mad. He's like making us out like we're hiding something. Like, we have these rules, you know, and whatever.
Oh, yeah, he's wrote, his, left. No. So I wanted to save all of them. I mean, because they're good for what we have. They're good at,
Oh, God.
He's always talked good about it.
Horrible. What's that?
He's always talked good about your presentation.
Oh, it's worst topic to have to talk about, so it's like you gotta do something to make it interesting. Nobody wants to hear about it. It's not exactly like I have a friendly audience a lot of times. It's either that or the early, like 8 a.m. Yeah.
So look, you better go in this, it's the 20. You get everything, put out.
They usually do the DUI when down here. Check, see if my truck's good parking for my truck. All of those long down here. I got a call in parking that doesn't. I had my sunroof open, but I was not that far from it. I thought it's get it wrong. You know, it is much time ago. Actually funny though. I do want that.
You gotta be pretty smart, Sam.
He's already solicited.
Yeah, a little bit. I'm good.
Okay.
It's mentioned it. That's the problem.
Lost and found.
Like a man.
Lost and found. It works. That's good. All right, just watch out for this deputy over here. He's trouble.
He's not real dead.
He's just playing the part, but he's still trouble. Life's hard sometimes.
It's not even 1:15. You all can be seated.
Energy bar, young.
Ms. Womble, are you ready? Great. Mr. Kathy, it's not quite time to start, but if you're able to, nothing wrong with us getting rolling.
You just kindly allow my co-counsel to get back in the room.
Sure.
But go ahead, get back on the stand, Gerald. Say it.
All right, why don't we get back on the record after our lunch break in the JQC matter involving Judge Gerald Johnson. When we broke for lunch, Mr. Kathy was wrapping up, getting towards the end of his direct examination of his client, Judge Johnson. And we'll pick up right there.
Gerald, be seated again. As I'm sure you're well aware, you're still under oath. We don't have to reissue an oath.
Yes, sir.
I wanted to talk to you about, we've presented to the court a 5 or 6 page chronology of your recovery, things you've done, comments you've made, and what you've learned, a good deal about what you've learned in your treatment for alcohol use disorder. Tell the court what you have done other than go to the formal meetings, go to the rehab, and attend AA meetings. Give us a brief rundown of what you've done on your own in the way of learning about the disease, learning about therapeutic modalities, and trying to make yourself well.
One of the things I did that as I began to recover and realize the mechanics behind some of the substance use issues, and most of it, excuse me, I picked up from the rehab and from the outpatient therapy, but you know, I wanted to understand more about the mechanics behind substance abuse. So I started reading a lot of material as far as information in the DSM-5. I've watched a lot of videos, and kind of in the back of my mind, what I was gearing that towards is if I was given the opportunity to go back and be the chief magistrate, how to incorporate that into what we're doing in magistrate court. Not to be a crusader, but to legitimately try to show a pathway for recovery, because one of the things that seems to be the common denominator in substance use disorders like my own is the stigma associated with it. And one of the things I think I told Mr. Boring on the phone is that I didn't know what to do. I knew, and this is not verbatim, but essentially I was saying I didn't know what to do, and I'm taking that responsibility for my bad actions, but you know, I never considered myself an alcoholic. I didn't know what kind of resources were out there. I'd heard about AA, and I've heard jokes about rehab saying that was for quitters, you know, things like that. So all that was in my mind. That's not something that I've embraced. And a lot of that had to do with stigma. One of the things that I really began to research is how stigma plays a role in people not seeking help or thinking that, well, this is just the way things are. But I'd like to, and it may be unrealistic goal for me, but I'd like to either, whether I'm chief magistrate or not, get involved in somehow to show folks there is a pathway to recovery. And just because that, you know, you made a bad choice and now you're dependent upon this substance, that there is a pathway to recovery. You can get better, you can get clean, you can be productive, you can do whatever. And it's not necessarily a bad thing to turn your back on that lifestyle and embrace a new lifestyle, because in my case, I'm happier now than I ever was. I hate these circumstances. I'm so embarrassed and so sick about this whole thing, because I've tried to remain unspotted from the world because of the public, because of the positions that I've been in. I completely understand that, but I'd used alcohol as an escape for so long, and then it became my prison. But I was to the point where something had to give, and I hated that this happened like this, but I'm so glad it did, because my life now is better than it's ever been. I mean, as far as the relationship with my wife, I feel better. I'm sleeping better. The nightmares have stopped. I mean, things are really good on a personal level. But I also understand that I've betrayed a confidence that the public put in me has put me in that position. I know there's got to be consequences, but to get back to your question, I'm rambling. I apologize, but just trying to find out everything I can, because the 12th step in the 12 steps is taking what you've learned and giving it back, giving that to others to help them recover. That helps me stay in recovery. That's the personal benefit to that. And plus, I mean, I've made my whole career around trying to help people. So
Do you believe you were a good judge before?
I do. Yes, sir.
Do you believe because of this and your recovery, you'll be a better judge now?
Absolutely. I really believe they're going to get a better version of the judge I was now that I've been through these experiences, because there's I hate to say it like this, but there's an empathy kind of factor that I've acquired where I don't look at, like I might have alluded to earlier, I don't look at drugs and alcohol as just crimes and offenses anymore. I mean, it's people that could be in a position where they want to get out of that mess, but they don't really know how, or they're not willing for whatever reason. But to be able to say, hey, there is a way to do this if you're willing to take certain steps. And of course, it's not a religious program, but it's spiritual in nature. And they don't have to embrace one of the very first thing that a person has to come to grips with is with that they're powerless over alcohol and their life has become unmanageable. And if they can get to that point 1 in the 12 steps, then that is the beginning of the pathway to recovery. And everything points back to that.
Judge, how should we work through a concern that because of what you've been through and what you've just described as this empathy factor that you are acknowledging you now have, the public might worry that you've gone maybe too far in the other direction, by which I mean, if now I'm the prosecutor, I think, I got this case in front of Judge Johnson and it's an alcohol case, he's going to go easy on the guy because he's going to say, I went through this and fortunately the JQC showed some leniency. I'm a judge again, and I'm not going to pursue these things as seriously as I might have if I were more objective. And no one is perfectly objective. You are clearly not objective anymore about someone who has become involved with the criminal justice system or some other regulatory group because of a substance abuse disorder. I'm wondering if you think that actually, while you would understand much more as someone asked to adjudicate it, it makes it more difficult for you to be as objective and impartial as the public might want you to be.
No, I completely understand your question and understand your concern, but for bad actions, there has to be consequences. I mean, that's the bottom line. If there's probable cause existing that a crime has been committed, then, that has to run its course. But, if you're dealing with alcohol, substance abuse disorders, whether it be drugs, heroin, fentanyl, alcohol, whatever the case is, incarcerating, and that's part of some of the stuff I've been reading about, is incarcerating someone will stop that interrupt that bad behavior, but it does not treat the underlying issue or the disease. And I had a hard time coming up with saying it was a disease because I took that drink, but then over time that tolerance and dependence develops, and then it becomes, like I said, what once was an escape then becomes a prison. But applying that to my job, no, there's got to be consequences. I mean, you've got to answer for your bad acts, and me included.
Well, I'm gonna quit. This will be the last time I ask this, I promise. Maybe Mr. Kathy can help us out. What do you think the appropriate sanction from the commission?
Could I, you said that, could I help you out?
Please.
And I'm ready to do that. Judge, can you activate the Elmo for me?
I sure can. I'm back in action. Let's see.
Good man.
Yep,
Uh,
it's coming on. There you go.
Actually,
Can you put it where we can see it, uncrooked it?
yeah, I'll try to get it. I'm not really good at this.
It's good. If it's just that paragraph, don't zoom in or out because it fits. Oh, you had it.
Way this came about is I am always, there's got to be a pony in here somewhere. So I still held the hope we could get a consent order. And I presented one to Chuck, and this is drawn as if we agreed to it. The IP would not agree to it.
I can't read it.
It's
I'll
intent. Is it
fix
part
it.
of the discipline by consent?
I'll fix it up for you, Richard, in just a
Maybe one of
minute.
those young people.
Let me get over here. All right. So what we did, and in the typical world, offers of settlement would not be admissible. I went over that with the director. But this is a deferred discipline agreement that we wanted to propose, and we worked on it with Dr. Oaks, who you will hear from.
Just for the, so the record is clear, the we, not here, that we, not the. director.
Understood. This would have been something you were sharing with the,
He shared it, yes. he shared it with me.
Investigative
I did not work on the discipline by agreement with him.
No,
He did,
no,
yes.
I submitted and it said, can we live with this? We
Was
used,
presented to the director, and the deputy director was presented to the lower panel also.
all I could do is present it. It's in this hearing panel now. I had no forum with the IP.
It was presented to the investigative panel. as well.
But Mr. Boring had to do that, and he did do that, and it was not agreed to. However, there's a lot of thought went into this discipline agreement. It's in number 10, and it does have some ambiguity because we said it's Richard. It's 10 with the last page, I think,
he's got it.
and it had some ambiguity in it because the ambiguity was that we would discipline approved by the hearing panel, that it would have conditions that the hearing panel would put on the judge. We have no precedent. Dr. Oaks will testify what he thinks would be appropriate. And it is random.
Treatment or a sanction from us.
Beg your pardon?
The doctor is going to testify as to what a treatment plan would be or a sanction.
I asked him if he were putting somebody back to work as a psychologist, what would he recommend? Under what conditions that person could go back? And I thought I couldn't just ask for something out of the blue. I wanted something that would make sense psychologically, recovery wise, and make sense to the system.
So you're proposing a 1 year to start, a 1 year suspension.
A 1 year suspension.
Without that.
Well, the pay was done by the county. Nobody had anything to do with it. Before I got involved,
I'm asking, your proposal for a sanction is either a suspension for a year with or without pay. Which one is?
it doesn't matter. The pay has been paid. The county, that deal was struck when he was suspended. This panel can't suspend him without pay because it's not state paid, it's county paid.
This is a consent. I'm assuming this is some type of a consent sanction you are proposing to us. Is that correct?
It is a sanction I'm proposing. You can't be by consent.
He wished it would
A
have been.
non-consent.
Correct.
sanction. But you're asking us to recommend a 1 year suspension. All I'm asking is, does he get paid every month or not when he's suspended for 1 year? That's all I'm asking.
Mr. Hyde, I think I may clear this up. I think he goes on in further depth in the consent agreement. He wants it to be
No,
backdated. Basically, the suspension is over, so there's nothing further.
Okay. Well,
Spending-
y'all are smart.
Yeah. As Gene Talmadge said, I was coming to that. He's been paid. The deal with him and his county commissioners was when he stepped aside, and in all candor, when he said, I need some help, I don't think anybody thought we would be here 13 months later, but we are. And he's been paid since that time. But there's no benefit to our system in the county for him having another year of sobriety, which would be 2 years. A 1 year period of sobriety is pretty good in the world of recovery. And we would like him to be reinstated, not pro tunc. The 1 year suspension, not pro tunc. Now that's a healthy suspension. We have a judge recently that got what, 3 to 6 months suspension?
Without pay.
Well,
This judge has been paid. You're not saying he's going to pay back the 13 months he's been getting paid.
that we are not, and the county is not involved in this.
The county doesn't have a thing to do with me.
They pay the money.
That's their business.
That's what I just said.
They want to pay a judge a gratuity or there's no benefit to the government, I guess they can do that. I don't know. My question is though,
I'm operating on the assumption that this panel will not have anything to do with pay since it's not a state payment. I just assume that. I
But
didn't
you
even
need
address
to
it.
answer his question.
Hmm?
You need to answer his question. Set aside what the county's done and.
I prefer it with pay, but the discretion of this course to do it without pay.
can you understand though, this isn't what I'm saying, but can you understand how the deputies down in Camden County are gonna say, that was just a one-year vacation with that? You understand that thought?
I can understand that those, you address it by this panel has to make decisions that are hard all the time. And you do pursuant to what our rules say, a reasoned and rational approach to what ought to be right for the person with that individual problem. We don't have a matrix we can use. We don't even have many precedents.
But is it true that the first obligation we have is to protect the integrity of the judiciary as opposed to an individual judicial officer?
Of course, but we all have, but I hope there's some degree of consideration for the judge. Else we wouldn't have the levels of punishment that are there, suspension, censure. I don't think anybody, we do have a one-year suspension that's been done. That's
Just
accomplished.
for the record, we're not allowed to give a censure evidently to anybody other than a statewide.
Right, we had that taken from us, unfortunately.
Yeah, well, what the rules say censure is available.
They do. They very much say that, but there's the part that's not printed.
But this court, this panel has flexibility to make a recommendation to the Supreme Court. And it should be based on a reasoned, rational approach to all the facts and circumstances. You're not going to find any case exactly like this.
We are on the same page with that, Mr. Kathy. All I'm saying is, because I know everybody in this room knows where this goes when we're done with it.
Yes?
And I will tell you, I don't think that the Georgia Supreme Court, who ultimately decides what happens, will accept a one-year suspension with pay new pro tunc.
Well,
just don't. So
I
I'm
quit-
asking you again.
I quit predicting what that court would do the second case I had down there.
Yeah.
So I'm not sure. I think the court's enlightened enough to look at the record and say, here's a man who was a perfect judge, who was a perfect law officer, had not one problem. In a few hours, he made a mistake. And once he's done, he spent 13 months making everything right he could to mitigate that.
I agree.
And that there's, and do we believe that person's going to be rehabbed? Do we believe that addiction is a disease? We say these things. Do we believe in lawyer wellness, judge wellness? Do we believe in those things? Then the punishment he's had has been pretty severe. If you could read our newspaper every week, it comes out. And a 12 months punishment is a 12 months punishment. If this panel recommended it some monetary, that he'd loss of pay, that he would have to reimburse the county, we will live with the punishment that this panel recommends, and that the court adopts it.
Just for my information, how much money have you been paid over 13 months from the county?
Mr. Osborne,
Annual salary.
well, I don't know. I was thinking it was like 86,000, but I read in the newspaper where they said 91,000. I don't know where all that is. My take-home pay is about $4,600 a month.
Okay.
But Your Honor, no effort was made by the people who pay the money to stop it and say, we're going to quit paying it.
That's absolutely irrelevant to me.
It's not irrelevant to the punishment though, because it interests you. It's concern for you. The money is concerning you. So it's not irrelevant to you. It's very relevant to you, the
But
money.
the county commission is not responsible with regulating the third branch of our government. We are.
That's right.
So
But they,
what the county commission does or doesn't do is irrelevant.
we will honor the recommendation. We will honor what the Supreme Court tells us. This panel has lots of flexibility. I'm telling you, we're answering the question that you framed, and you asked me if I could help you with it.
And you've
What I
helped.
think the
Let's-
punishment would be.
You've helped. I appreciate, and you've pointed us to that paragraph on page 9 of Exhibit 10 that we can go back to when we need to.
Right, and we also, Your Honor, if the panel I think this is addresses some of the things. The director and Judge Johnson believe that suspension will serve as an indication to lay people that the court will maintain the ethics of this profession and will best serve the administration of justice. Additionally, it offers to those who suffer from a treatable addictive disease that rehabilitation and recovery is possible and that a return to productive activity can be accomplished. We want to send that message to people. Come to the JQC, rehabilitate yourself. You might get your job back. Because if you've demonstrated, he was a great judge before, he's going to be a better judge now. Now, if we go and get it, if he's allowed to get his job back, how do we address the element of sanction? What is the best one? That's hard. I don't.
Interrupt you just for a second. Closing argument. I know you're going to want to say that again, so let's save that for closing argument.
Okay, well.
We've got other questions for Judge Johnson. Let's work through those.
Judge, are you continuing in your recovery?
Yes, sir.
Are you still sober?
Yes, sir.
Are you still living a clean and wholesome life?
Yes, sir.
Are your wife and you in good harmony now?
Yes, sir.
You wish to return to the bench as magistrate judge of
I'd love to
Haversham
go back to
County?
work.
Are you willing to adhere to the conditions placed on that, even though the public will look at you and wonder about you, and you will face the ballot box again? Are you willing to accept those conditions?
Absolutely. And like I've said a couple of times, I think there's got to be accountability, and I've broken some of that trust, and I'm going to have to build it back if I can get it back. I'm maybe presumptuous in that.
That's all.
Mr. Boring, do you have questions for Judge Johnson?
I do, Judge.
Before you start, I have a couple more. So Judge Johnson, share with us the electoral cycle. Was there already an election and you didn't have to stand because you were suspended, or when would you next be on the ballot?
No, I'd just gone through an election in 2020. Is that right? And I ran unopposed. So I was actually in my first year of my second full term.
So you'll be on in 2024?
Yes.
Okay. You've mentioned several times that you had been drinking for a while, that tolerance had been built up, et cetera. How long would you say, now that you have had a chance to think more about the illness and your recovery, how long, weeks, months, years, were you addicted to alcohol or engaged in the substance abuse disorder? Hang whatever term you want on it, but I think it's important for us to understand how long that had been going
I
on.
understand. Through the course of my adult life, I've been what I would consider a social drinker.
A what?
A social drinker, just drinking, not I mean, just a drink here and there, or on the weekends or during an event or something like that, not to the level that I was at in the date in question. I think what I qualify as is maybe some kind of a binge drinker possibly prior to this, because I would go for long periods of time and not drink anything. But if I did drink, I would drink a lot. And
How does that build? I'm not asking for a scientific answer, but I guess that's not what I understood you had been saying before, that you had built up this tolerance because you drank so much for so long that on this morning in question, when you wanted to drink enough to get your courage up, you actually had to drink a phenomenal amount. And then you became, it sounds like, largely incoherent and doing things like shooting your gun in your backyard.
it was the year prior to the pandemic when I started drinking a little bit during the week, and that started progressing, drinking a little bit more during the week. But there also, again, it was to my excuse that I used was that, well, it helps me to relax. I thought it was helping me sleep and that kind of thing. But then as paralleling the pandemic, I'm not blaming the pandemic, but when there was less to do outside or whatever, we were staying at home more, I started drinking more during the week. And then, of course, go to bed, get up in the morning feeling like awful, but go to work, dry as a bone, suffer through the day, physically suffer through the day, do my job, go back home, take care of the dogs. Then when everything got settled, I would have a drink, and then that drink would turn into 2 and 3. And then it got to where, and it's textbook, according to everything I've been reading, the progression of the alcohol disorder, or whatever you want to, like you said, whatever you want to call it. I was the one putting the drink up to my mouth, so I'm owning that. But there'd be, especially on Monday mornings, be like, I need to cut back, I need to quit, I don't need to do this anymore. Because I'd go to work sober, and sober did not feel good anymore. And so I, would get through the day, and that cycle repeated, paralleling the course of the pandemic, because during the day, there was a period of time where we're doing stuff, teleconference, and I was doing my warrant. I've always done my warrant hearings, and well, not always, but for the majority, since I've been chief magistrate, I implemented the teleconferencing so I could do the warrants and do the first appearances and stuff like that via teleconference. Well, the pandemic, I was already set. I was ready. So I was doing that stuff from home, go through the course of a business day, and then evening was my time to indulge.
Okay.
And the progression was the tolerance build up during that time. So it's not been like since I was a kid or anything. It progressed very rapidly, in my opinion. And I'm certainly not proud of that. But can I say something in reference to the suspension? To talk about the year that I've been suspended.
Okay.
I just want to say roughly, or briefly, not roughly, but this is the worst experience I've ever had in my life. And I mean that sincerely. And I brought it on myself. From the time that Mr. Boring was kind enough to tell me that, this, I'll never forget what he said to me on the phone. He said, this may be a blessing in disguise. He said, but would you agree that the facts and circumstances are enough to merit a suspension? I said, absolutely. He says, do you think you need to be here in cases? Essentially something like that. I said, no, I don't, because I'm here. This is where I'm at. All that was submitted in consent form to the Supreme Court, who did an order that says the judge will be suspended with pay. I was relieved because I didn't know what I was going to do. And when they said with pay, I was like, thank you, Lord, that's going to help me pay bills, which in fact did help me to maintain and help my recovery, because while I was getting paid, I was in rehab for 35 days. I went to the 12 weeks of outpatient therapy during that time. Once all that had stopped, I continued doing my AA meetings, but I took the assembly line job as a way to fill in that void. So, but that's how the pay came into
Do
it.
you understand there's no authority for you to be suspended without pay other than from the Supreme Court, or if you're indicted?
I'm
The
not,
investigative panel nor this panel has the authority to suspend you without pay.
I understand that now, but that order came from the Supreme Court.
Okay.
Once they granted the consent motion that Mr. Boring had prepared and I signed, which was pretty damning in itself. But I've tried to be most cooperative because I have the highest respect for this gentleman, whether y'all believe that or not. I think he's got a tremendous responsibility of trying to keep the judiciary protected from, so the public doesn't, question their judge's ability to, I completely understand that. And he's been very kind to me. So anyway, I just wanted to reel that in as far as the pay issue and the suspension, but it has not been a cakewalk. It's certainly not been a vacation, because I've isolated more in sobriety, because until just a few minutes ago, I thought if I talked about anything to do with these proceedings or this investigation or this case, that I could be held in contempt of the Supreme Court. So I was afraid, because of my transparent thought processes, that if I went to the local grocery store and somebody said, hey man, what's going on with you? I didn't want to talk about it, because number one, I didn't think I could. Number two, I'm embarrassed to death. So I've just really been in exile for the past year and a month, and I'm not even returning phone calls. I'm just staying away from all that, because I didn't want to, it's not been a vacation. I promise you. I have suffered tremendously over my bad choices. I mean that sincerely. Thank you.
All right. Good afternoon, Judge.
Hey, sir.
Kind of picking up where they left off. Luckily for you and for everybody here, probably the hearing panel and Mr. Kathy's covered a lot of territory, so I don't have too much to go into, but kind of on that without pay thing, you realize that's been interpreted by the courts as constitutionally, we can't suspend you without pay. So that's not like my druthers. I may have a different opinion on that. So you get that, right?
I'm gathering that from what y'all are saying now. So
Right.
yes, sir.
All right. So I do want to talk to you a little bit about not You've talked about accountability a lot. I appreciate that as a part of this process and a part of any type of disciplinary process. What I want to talk to you about is what I think is very important to the hearing panel's decision is your ability to be a judge. And when I'm asking these questions, I don't mean them as your subjective belief about whether you can do a good job. More like the public's perception. You talked about, the media being in here. You would agree with me that based upon your actions, the public probably has less confidence in the magistrate court of Habersham County now.
Less confidence in me. I don't know about the court.
Well, as the chief judge, you as a judge, you would agree that they probably have less confidence at this point.
I would say there's probably quite a few. And then I would also like to believe that there's some that believe that I'm still a good person, that the good and bad still makes me, me.
Right. And you understand good people sometimes do things that are bad, and they have to A, be held accountable, but B, they may not be able to carry on in the same manner that they have before.
And I use that line hundreds of times in interviews, but I also believe that just because you do something bad doesn't mean you're a bad person.
Absolutely. And so, this hearing isn't about whether you're a good or bad person. So, one thing I want to ask you about a couple of hypotheticals. If you were a judge, let's say, you've got Sheriff Terrell, great sheriff, you've got great law enforcement up there. They're constantly going to be bringing you cases as the chief magistrate, correct?
Yes, sir.
And they did the investigation into the incident that happened with you, correct?
Yes.
And they made the decision not to arrest, whether good, bad, or indifferent. They made that decision after investigating the incident, correct?
Correct.
You would agree that a defendant that they investigate that comes before you may have some thought about your partiality, given that the Habersham County Sheriff's Office who investigated you is now investigating them. You see how a defendant in a criminal case may have reservations, right or wrong?
Well, I mean, that would call for me to speculate what they're thinking, but I mean, as far
You can see the appearance. Would you agree with that? That there could be a problem with appearances?
I think some people could have a problem with anything that I do because I'm a judge.
Right.
Or was a judge.
Let me ask you this too, just not necessarily from a defendant in a criminal case, from a public's perspective, or like say a victim. Let's say you're a magistrate court judge and you have a criminal case that comes before you where you have a defendant who is intoxicated, who either in a domestic case pulled a gun on somebody or was intoxicated and shot somebody because they decided to do a robbery, or for whatever reason, they were intoxicated and pulled a gun or shot somebody. Do you think the victim of that crime or the victim's family may have a problem with the appearance, given that you have gone through this and basically arguing for, to stay on the bench as a judge, even though you've pulled a gun on a law enforcement officer?
I think that part of my job is very simple because it boils down, it's a question about probable cause, right? Probable cause is a set of facts and circumstances that would lead a reasonable and prudent person to believe that a crime has, is, or will be committed. As long as I stick to the facts and apply the appropriate code section, crime, whatever allegations are, just because that a warrant issues does not mean that person is guilty of that crime. That means they've been accused of it and they'll have their day in court. If I was in a position where I had to justify anything I did, I think the bigger challenge would be when I don't issue a warrant, when there is an absence of probable cause or the facts and circumstances don't support the elements of a particular crime.
Which is where then the victim and the victim supporters would
Be worried
about this, that, oh, of course, Judge Johnson didn't issue the warrant on this one because he's empathizing with the alleged accused. It was just the alcohol talking, and not saying you'd ever put it this way,
I understand.
but that's the perception I know that we'll be talking about, is how could a judge who's gone through what you went through, who's done what you did, be viewed by the public as someone who, in a situation that could repeatedly appear before you, be viewed as impartial, even though in here, I'm actually going to be wiser and more broad-minded about things. That's not the test.
Well, I think the key to success in that set of circumstances would be transparency, but I don't know exactly what the venue would be to get the transparency to the public, because technically, I'm not supposed to talk about pending cases and those kind of things. So that is a challenge.
And I think that is the problem. And I'm not asking about like a subjectively and whether you really could be fair. You know, we're not
I
arguing
understand.
about whether you can be fair or not. It's the appearance to the people
appearance.
involved.
I
So
understand.
you understand the problem we're all struggling with on that.
Right, I do understand. But Habersham County is a relatively small county. I think there's 43 to 46,000 people in the community. It's hard for me to think from that angle simply because I know my own personal candor, I know my own transparency, I know my truthfulness, and I know that I don't have a hidden agenda. I mean, it's not, when I talk about the issues concerning incarcerating people for drug and alcohol related offenses did not necessarily treat the root issue, whether it's drugs or alcohol or whatever the case is. I've said it over and over, and I would just have to preach that from the rafters that there's got to be consequences for bad actions, whatever those be, whether it be sanctions, whether it be jail, whether it be prison. But I'm also saying that I understand that people, have a treatable illness under those circumstances with alcohol and drug abuse kind of things. And, as part of my recovery, like I said, that 12th step is about helping others and educating others. My thing is I want to share this with whoever will listen. So whether it be something that I do publicly, as far as giving talks about, how does the substance abuse disorder and treatment apply to the judiciary or to law enforcement or to the defense, because I'm not taking a side either way. I'm not going to say that I'm not going to issue a warrant. I'm going to issue a warrant out of fear that somebody's going to say, "Oh, he's a drunk and he's helping other drunks," that kind of thing. That's not the case at all. I think just public awareness, or maybe even, if the newspaper would indulge me, I could maybe write an article once a month about substance abuse and how that applies to the judiciary. And, I've been open. I know this is being broadcast all over and he's sitting right there. So it's all out there.
Right.
That's how I am.
Right. And I think, that's kind of the problem here, and why this is different than, say, a criminal setting is we're not just looking at a criminal sanction or that, we're looking at the impact on the public. So kind of on that vein, I know you were talking about the day of the incident and talking about, making a determination of probable cause. You understand voluntary intoxication is not a defense, correct?
I do.
And nobody forced you to drink that day. You had problems, you had issues, and I'm sure we'll hear from your expert about that, but you're the one who made the decision to do that, correct?
The decision that I made October the 18th in the wee hours of the morning was to shoot myself.
Right.
And I tried to use alcohol as a vehicle to gather the courage to do that, sir. I don't really recall all the other mess that happened after that. It was all bad. It was none of it good. I can't sit here and explain to you why this happened or that happened. My goal was to not be here today. And in the early stages, that seemed like a pretty good option still, simply because I didn't want to have to go through the guilt, the shame, the embarrassment. And Lord knows I had no idea I would go through this much therapy and counselors and therapists. And it's embarrassing to sit here with you because I have the utmost respect for you. And I know I keep blowing smoke at you, but I really do. And to have you opposing me is painful. I mean, it really is.
Well, I will say that is one of the idiosyncrasies of this job. It is not comfortable for me either, but we have to ask some difficult questions.
I
And so
understand.
kind of in that regard, on that night, you did, even though you were intoxicated, maybe it was because you were under the influence of alcohol that contributed to cause you voluntarily had the gun initially for the purposes initially, as you said, to commit suicide.
That is correct.
And you voluntarily went outside and you popped off 9 rounds into the backyard, correct?
The only reason I know, yes. And I know it was 9 rounds because I found the cartridges. There was 5, I think, on the porch and 4 on the ground, not the 2 magazines that somebody alleged that there was 9 rounds.
And I know when you first went to the door, you didn't know it was Travis, Lieutenant Gerald, who was there, but you went to the door with the AR-15, correct?
I had it manned, as I recall, yes.
And do you remember that he'd actually rang the doorbell?
I don't remember that.
Okay, but if he said that, then that you've no reason to contest what
I
Travis
would
said.
never contest what Travis is saying. If he said he rung the doorbell, knocked or yelled or whatever, I wouldn't argue with him because he's Travis. He's a really good guy.
And no one, you didn't, you made the decision to raise the gun at that point, correct? After you opened the door.
See, and I want to cooperate with your line of questioning, but honestly, I think it falls back on muscle memory, and I did it. Obviously, I did it. But
Yes.
it's not like I went to the door with the idea that I was going to draw down or whatever. I think it was muscle memory. And the way I went through the door, like I've done not my door, but like I've done so many other people's doors over the course of 25 years, that barrel is pointing where my eyes are looking. And that's whether, are you a threat or are you okay? Once the threat is dispelled, I move on. And that's why I was so shocked when Travis ran, because I remember thinking to myself, what's he running for? Then it occurred to me, he's scared of me. And that was horrible, horrible.
And I know you don't remember this, but you know, Travis has said that you said, I didn't call the law. You understand that, right?
I do understand that.
Okay.
I don't remember saying that, but I mean, if he says I said it, I said it. And it does sound like something I would say, but the thought process possibly behind that is the way I think under normal circumstances, which is I'm not going to call the police over something silly.
Mhm.
I'm not going to call 911 over something silly, and having been 20 something years, and maybe that's ego talking, God forbid, but you know, I feel like I can take care of my own business. And so I could have said, I didn't call the law, meaning why are you here? Because they always text or call before they come.
Right.
Sorry.
I know we talked a lot about this being law enforcement. Let's just say hypothetically, it was a Boy Scout that was coming door to door and you pulled an AR-15 on a child.
What's the question?
Do you think at that point you have done something wrong?
I can't imagine me ever pointing a gun at a child intentionally.
Okay.
But let me also add that I cannot remember, but I know myself well enough to know something put me into that combat mode. It wasn't just a knock on the door. I don't know if there was a noise I heard or something caused me to be thinking there's a threat, possible threat outside.
Possibly the alcohol contributed to that.
I don't know. I can't explain it. I can't
I got
offer
it.
it. All I know is I did it, and
Right.
it wasn't a Boy Scout. It was unfortunately poor old Deputy
Right.
Gerald.
And you agree that what Travis said, with the facts you've stipulated to, you pointed an AR-15 at Travis while he was in the lawful discharge of his official duties, correct?
You keep
He
harping
was
on that.
scared.
You keep harping on that point.
Yep.
but I would never hurt Travis. I would never do anything intentionally, but he said it happened, so I have to agree with it.
And no, nobody's saying that you intentionally ever would have done that. But you've had cases before as a magistrate court judge, right? Where you've had somebody who in their right mind, not intoxicated, would never do something criminal, but they may do something horrible. You would agree with that? And they've still violated the law. Would you agree with that?
Well, again, as a magistrate judge, the only actually adjudication I'm involved in is county
There would be
ordinance.
probable cause for it. You would agree with
Probable
that?
cause, yes.
Okay. And for instance, let's just looking at some of the laws in this case that may have applied to you at the time, if it were a different circumstance, well, under your circumstances, you agree that you were discharging a firearm while under the influence of alcohol, right?
Yes, sir.
Okay. And you would agree you were in no shape to drive, right?
Yes, sir.
Not that you did drive, but your blood alcohol content would have been well over a 0.08. Would you agree with that?
Most likely, yes, sir.
Okay, and you're familiar with OCGA 1611-134 about discharging a firearm under the influence of alcohol?
Yes, sir.
Okay.
But there again, going to if I may elaborate on that.
Sure.
I can't remember the exact verbiage of the statute, but doesn't it say with something to a reckless disregard for the public or unjustifiable risk to the person or the public?
That's reckless conduct. Yeah, 1611-134 is discharging a firearm under the influence in an unsafe manner. In this case, you already had a gun to your head in front of your wife, or 0.08 while doing so. over that blood alcohol level.
So the only thing I would, as a magistrate, if I
Yes.
were hearing this case, I
Mhm.
would be weighing in my mind is that what and if there was an unsafe manner.
Do you think discharging your gun out in your backyard in a public area and then pulling a gun, pointing it at a law enforcement officer, whether you meant to or not, don't you think that that may be an unsafe manner? You were in no condition to handle a gun?
I didn't discharge the gun in phase 2 of that. Phase
No, in
1,
the backyard.
I was in the backyard, standing on my porch, shooting into the ground.
You would agree, the condition you were in, it was not safe for you to be handling an AR-15. Would you agree with that?
For the sake of argument, yes, sir, but I shot into the ground.
Just generally, sorry.
You don't need to be agreeable. You need to be honest. And so if you think that you are in the right state of mind and control over your faculties, after all you told us you've been drinking, that it was safe for you to be handling a loaded assault rifle and then firing it repeatedly into your backyard. If you think that was safe, you should say, I think that was safe. And I don't agree with him because he asked.
Well,
And if you don't think it was safe, then say, you know what, it
Well,
wasn't safe. And
again,
there we are.
it goes back to perception, because in my mind, I do remember shooting into the ground. Again, the scenario or the circumstances surrounding that was the dogs barking, all of the noise, and that was my irrational thoughts to, get some quiet, was to discharge that weapon into the ground. But no, it's not reasonable. It's not safe to be intoxicated handling an AR-15. So to answer your question, yes.
I just want to ask you a few questions about that, about leading up to the incident with Travis. I know you talked a little bit about, you've been struggling for a while leading up to that day. And I think you'd said before, if you haven't, just to make sure we're clear, the suicidal ideations and feelings you had, those were something that you had been dealing with sober and intoxicated over the course of the past year, correct?
I don't recall ever. I know there's been talk and it's been said that I've made those allegations in the past, but I don't remember any allegations of wanting to shoot myself or hurt myself. The challenge that I was having this particular weekend, if I can elaborate very quickly, was the challenge I was having is that it was my wife's birthday weekend.
I was about to get to that. I may be able to speed it up for you in that regard. If it would be easier for you to just, I'll ask the
I mean, it's
questions.
all related. I mean,
Yeah.
it's all happening in
And
a very
so
short amount of time.
Just,
I don't
yeah.
want us to lead. Your initial question
right.
was, so in essence, isn't it true that it actually had been weeks or maybe even months that you'd been grappling with some self-harm issues? Your answer was no.
No.
So I want you to give us what you think the correct answer is. And you had said, I think it was really just that weekend is when you first started feeling an impulsion to hurt yourself, take your life. You were going to explain why. And so if you want to guide him there, that's fine. But his answer is different from what your question was.
Right. I think that the objection would have been non-responsive, I think, to what he was going to go into as far as the suicidal ideations. I think this was
Okay. But I want to make sure I'm following it.
Okay.
You disagree with the way the question was framed, which is, isn't it true that for months you had been thinking about harming yourself? It was really the first time you were feeling that was that weekend.
Yes,
Saturday, Sunday, and of course the 18th was a Monday.
yes, sir. That's correct.
All right.
And have you listened to the body cam video that the hearing panel is going to have?
No, sir.
Okay. Did you know that your wife's on there telling the lieutenant that you've been having these ideations for a while and that you were sober when you were actually saying that?
I'd heard that, and
Okay.
I don't know why she thinks that. I mean,
Yeah.
that's but
That's why I asked the question, because we have that
I
information.
understand.
That getting to that weekend, I believe you talked about it was your wife's birthday and y'all had gotten in an argument, right?
Well,
Because you'd fallen asleep on her birthday and y'all, like you were talking about, silly, intoxicate, you're drunk
when
arguing
I
about
told the
things.
investigators that, I was trying to make sense of it myself. I don't really honestly know what the problem was. All I know is, bless her heart, and I don't want to say anything bad about my wife because she's the sweetest person in the world, but she got,
And she's sitting right there.
and she's
So,
sitting
yeah.
right there. But she she got it in her mind for whatever reason, I'm sure I did something, but that I'd ruined her birthday. And the only thing I could think of is that I went to sleep because I didn't do anything. There was no drama going on.
Right.
But that started Saturday night and went through Sunday. And we always leave the cabin together. Well, she left me there at the cabin by myself, which was totally out of character, totally unusual. I'm thinking, oh no, this is the end. Everything unraveling, something terrible's happening. And so I ended up going home. Now we're sober, because I don't drink and drive. I go home. And while I'm at home, I started drinking again. And then through the course of the night, she's just not talking to me. We're not having any communication. And I truly, for whatever reason, I'm sure it was alcohol influenced my thought process, but I got it in my mind. She's done with me and this is it. It's over. So at that point, the career, none of that stuff really mattered. And there was other things that I was, wrestling with that it's totally irrelevant, but I mean, it's just thoughts I was having, my son, he had gotten married, against my wishes. And I was thinking about how my life had progressed up to this point and I just got it in my mind that this was just horrible and that I was going to take care of it Monday morning. So that's how all that come about.
And so I guess the drink Sunday kind of turns into Monday at that point.
Well, I slept some Sunday night and then I woke up early Monday morning and come to that conclusion.
And you were supposed to work Monday and you called in sick, correct?
I did.
Okay. You knew you weren't in a position to have to go in, not necessarily from alcohol, but mentally at least.
Oh yeah, no, I couldn't function because it was boss's day and I had an idea that they were going to do something nice for me and I couldn't face them. I couldn't deal with it. And
your wife was worried enough to stay at home. She called in that day too, correct? Because she was worried you're going to hurt yourself.
I don't know what she was thinking. She wasn't talking to me. But I know she stayed home.
Okay. Did you see that well, never mind. I won't ask you that question if you don't know. And I know you talked a little bit about your alcohol use on direct. By this time, you were drinking daily, correct? Not just on the weekends, but every day at this point.
In the evening, yes, sir.
Yes, you get home from work. And so it was a daily thing. It wasn't just on the weekends.
Yes, sir. Yeah, it evolved into the
right.
And it started, small and then progressed into whatever.
Gotcha. I know there was, you talked about the dogs barking and the things that kind of set you off or whatever words you used to go out in the backyard and, shoot your rifle. When you talked to our investigator, you remember talking about some other things that you were upset about that day.
I vaguely remember there's a convenience store that I think I mentioned to them where they're doing whatever that gambling business is that they do in there with those little machines. And there's always a crowd out there and there's always engines racing and things to that effect.
Right. And you said
Near your house? Why would this be bothering you?
I can hear it. It's not like right there at my house. It's further down the road.
But close enough that the engine's revving or racing, you could hear.
Yes.
Okay.
Yeah. And you
I mean, they go down the road from that store. 'Cause we live, the subdivision is on an old county road that intersects with 105 and the store's like up here. So there's a stop sign and then this stretch of road where.
And I think you told them that this store is close enough where you can hear people laughing and carry on at the store, correct?
Well, not necessarily a normal conversation, but when they're yelling and carrying on, I can hear it. I've heard several disputes and things like that. The sound carries up to my.
Right. Do you remember telling them too that it bothered you that you could smell cigarette smoke coming from the convenience store too?
I don't remember saying that, but
Is that something you had a problem with? You remember?
I don't remember that. I mean, I'm not saying I didn't say that, but I don't remember saying that.
In this statement we gave to our investigator Gossard and Jeff Davis, that was over a week after the incident with the police, correct? Do you know how long it was?
Yeah, I think so.
Okay. If they talked to you on October 26th, and the incident happened on October 18th, and that was a little over a week, correct?
That's correct.
Do you remember telling them about students from some outlaw school and a bunch of hoodlums that were there that you didn't like the sight of them congregating there? That was another thing that.
Well, again, I'm sure I said that, and let me also clarify something else, that when I was talking to them, I thought we were just talking.
Okay.
And I may have made reference to that school. It's not an outlaw school. It's a school that caters to students that, for whatever reason, aren't going to the regular public school.
Exactly. Yeah,
So,
right. And I think you talked about there also being, I'm gonna use the term I think that you use, a meth shack nearby. You remember that?
Yeah, I remember that.
There's some vacant building behind your home that had been turned into a residence at that point.
Yep, I do remember that.
Okay. And do you remember that people were coming in and out of that building then?
Yep, when they were working on it, that certainly was.
Okay.
A lot of activity, a lot of loud voices, a lot of disputes, and just, yeah.
And you remember complaining a little bit about, I guess, one of your, I won't name the neighbor or anything. That neighbor had a son that was causing problems, I guess,
No,
walking up and down the street or.
yeah,
And I think at that point you said that was where all of this chatter and everything, that's when you kind of snapped.
yeah. I had a lot on my mind. Yes, sir.
And after this, and I'm not going to go into the issues of hurting yourself anymore. I think we've covered that enough. At some point you get into this argument with your wife. Do you remember throwing the things around in the house?
I don't remember doing anything inside the house. The only thing I remember doing is when she went for the car, I didn't want her to drive off or get in the car in any event. That was a recipe for disaster.
And
Because she had been drinking, or in general, she doesn't drive?
Because she'd been drinking. Okay. I don't know how much she'd been drinking, but I just knew that was not a good idea.
And so you had to, I guess, at least you had enough of your faculties to realize you needed to stop her from driving.
I wanted to encourage her to get out of the car. I wasn't going to stop her,
Right.
but I wanted her to get out of the car. I wanted her to stop what she was doing.
And before you get to that point, do you remember damaging a trash can in the house?
No, sir.
Okay. Did you see the trash can later that had been damaged?
I didn't see any damage to it. There was a dent, looked like.
Okay, a dent in it. Do you remember doing that, or do you not remember doing that?
I don't recall doing that at all. But I mean, when we're talking about a dent, we're talking about maybe probably 4 to 5 inches, whatever. I mean, it didn't look like I was over there beating the trash can or throwing it around or anything.
Did you remember taking your phone from your wife, taking her phone from her?
No.
Okay. And all these things, if she told the police that these things happened, you would have no reason to doubt that that was true. Would you agree with that?
The only thing I would question about that, and not to say anything negative about her, but she's told me so many times from that day forward, she was trying to do anything she could to get me help.
Mhm.
And so I don't know if she, I don't know. I don't remember doing any of that stuff.
Do you remember the 911 call, after the police responded, they heard gunshots, obviously, that was most likely you, that they also reported they'd heard a man yelling and banging on something. You remember that from reading the police reports?
And I really don't, the yelling, yes, because I think I told the investigators I yelled twice before I fired the weapon. But and not to downplay it, because I'm bad. I did all these things.
Right.
But our back door doesn't close good.
Mm-hmm.
And the only thing I can imagine, because I know, well, no, I don't know. I'll take that back. I was told that Laura got upset because I had the door open, because we have 2 dogs in the house.
Mm-hmm.
And she was afraid the dogs were going to get out.
I've heard them barking on, and they'll hear it on the audio of the dash cam, the dogs barking. So,
Okay. Well, anyway, she's afraid those dogs are going to get out. And she told me long after the fact that she's the one that was closing the door, but sometimes it doesn't close good. So you have to kind of slam it. And I still have to do that. So I don't know what the banging was, shooting, yelling, that's me.
And as far as you agree, you're the one who broke the windshield, or cracked the windshield, however you want to term it.
Yes. I mean, for the sake of time, that
Yes. And you agree that your wife, because she didn't want you to get in trouble. At some point, she said that she had done it, or that you had not done it. But then you remember telling our investigator, yeah, you actually were the one who did it.
Yeah. Yes.
And you've done this long enough, you know that that's not out of the ordinary in these types of situations.
What's not out of the ordinary?
I'm sorry, where you may have one party that says one statement at one point, somebody that's, going through a domestic issue, and they may recant even though it was the truth.
Oh, having people recant.
Yes.
Usually it's when they get to court, but
Right.
not at the.
Sometimes a little earlier.
Right.
Okay.
Um,
All right.
I wish I had pictures of the windshield though, because that honestly, it cracked, but it wasn't what you would traditionally see
Mhm.
in a family violence situation with the spider webbing and the huge gouges and whatever. And I didn't even know that the windshield was cracked at all until I went to get it fixed. There was a crack that started up at the top corner and kind of came down and went across the windshield the way I recall it. It wasn't one of those big spider webbing things, because if I wanted to break the windshield, whether I remembered it or not, it would have been lots of damage, not just a little crack. I think there may have been a bad place in the windshield anyway, that when I was putting that pressure, either with my hand or a Swiffer or whatever, caused it to crack. So it's not like you would think with a, get out of the car, not this crazy lunatic thing. Well, I mean, I don't know. I don't remember, but I do remember wanting her to get out of the car and tap
Right.
on it, just like I would do when I was sitting on the bench.
Mhm.
That's what I remember doing.
So the case, I know that you weren't arrested, and the case is still pending with the district attorney's office in Hall County, correct? Or do you even know which
I don't
county
know.
has it? So they haven't
I
decided.
know it's in Hall County based on what my attorney Adam told me, and I know that it's under review, and nothing's been said or done forever.
Right. I'm going to ask you kind of I guess a tough question, hypothetical.
Go ahead.
The state you were in, as intoxicated as you were in, when you pointed that gun, because whether you remember it or not, or however it happened, if you would have pulled the trigger and shot Travis, what do you think should have happened? What do you think would have happened with you?
I object. Trigger was pulled. Had a lot of testimony. It's a hypothetical question.
Judge, we've had a lot of speculation and hypotheticals, and I believe this is,
There's nothing, there's no basis for that hypothetical question. Trigger was not pulled.
I'm going to allow it because I've had a similar thought. We've had a lot of exploration of, well, you didn't shoot and you meant Travis no harm, but of course it's his perception that would control. No charges have been brought. It could have had a different outcome. And I think it's allowable to explore what Judge Johnson thinks ought to have happened to him had it been. I appreciate it's a different outcome. That's not where we are, fortunately.
We can go ahead. What if you turned and shot your wife? She was in the house. That hypothetical could have, we could just go 1,000.
Well, we don't
I'm
have
not-
any evidence that he pointed the gun at his wife, but we do have evidence that he pointed the gun
We
directly.
don't have evidence. We'll pull the trigger either.
True, that's why we're here and not in a criminal court. You can answer the question.
so if you gone that one step further and actually shot Travis, what do you think would have happened with you?
I think I would have been arrested. I think Travis's family would have been devastated. I would have been devastated. But let me also add too that going back to 22 years of handling firearms, and I'm not bragging when I say this, it's just the nature of the business that I was in. You can ask any police officer, any deputy sheriff, any trooper. We are all trained the same way when it comes to using that firearm, and that is trigger out or finger outside the trigger well until you're ready to engage your target. Then the finger goes in. I know to a scientific certainty, because I've done it so many times, that as the barrel of that weapon, unfortunately, and as horrible as I feel about that particular set of circumstances, when I recognized who it was, I did not engage my trigger. And I'm sure I took it off the ready. I don't remember pointing it at him, but I remember looking at him and watching him run and thinking to myself, it's the police or it's Travis or, I know him, it's Travis to me, Travis Gerald, he's the deputy sheriff. But I know, drunk or not, that finger was outside that trigger well because that's the way I do every time I have a firearm in my hand.
You're also trained, you're not supposed to use a firearm intoxicated, right? Especially to a level where you have memory problems and don't remember what happened.
That's never been a part of my training, but I would agree with that statement. Yes, sir.
Yes. And you realize in this case, I think you told the investigators, at least our investigator and Jeff Davis, that Travis would have been justified in shooting you at that point.
I told the investigators that I think it would have been a good shoot as far as an investigation goes, because I had the ability, the opportunity, and he felt like he was in jeopardy because he ran from me. I realized I scared him. Now I'm talking facts and circumstances and legalese. It would have been a good shoot. In reality, no, it would have been horrible because I would have never, ever pulled that trigger. I would have never hurt that deputy or any other deputy, or whether it was a deputy I didn't know. I've always said this, that if it's wearing a badge, it's welcome, but it's not a.
Well, just for argument's sake, without the alcohol, you wouldn't have thought about killing yourself that day, correct?
No, I made that decision long before I started the heavy drinking.
Well, you wouldn't have gone out and banged on your wife's windshield like you did, would you?
To protect her from herself, probably.
When the police showed up at your house, when you got back, you made that trek, you finally went to your mother's. When you got back, do you remember 2 deputies showed up, correct?
Yes.
Okay. And you remember telling Investigator Gossert and Mr. Davis that you thought you were getting arrested that day.
Yeah, because I mean, the way they were acting, they were obviously something was going on and I was involved.
Do you remember telling them at some point you'd gone back to work that Wednesday, but you knew, quote, the hammer was going to fall at some point because too many people were involved?
I probably said that.
And when Sheriff Terrell came to talk to you, I know you were surprised by, I guess, his reaction when he came in and gave you a hug and told you he loved you.
Yeah, that caught me off guard.
And do you remember telling our office that you were expecting to be arrested when he showed up there?
I knew it was a good possibility because, I mean, again, probable causes and perception and all the stuff that you're trying to make the points.
Right.
I know where you're coming from, but I also know me.
Right. And again, I'm talking about an objective standard, not a subject.
I understand.
Okay.
But even though I don't remember all the people that's involved in this that said I did this or said I didn't do that or whatever the case is, I don't know. All I know is what they say, and they're good people. And I don't think they have any vindictive and any vendettas against me. So I have no reason not to believe them.
Yeah. And do you remember on I think it's on the audio of the first occasion where they came to the house, where you asked Travis if he was going to arrest you that night?
Did I ask Travis?
Do you remember asking Travis that, are you going to arrest me?
No, I don't remember that.
And just kind of a few other questions do you remember about your interactions with Travis at the scene, the first occasion when he came out? Do you remember those times where you were asking him to turn off the camera, turn off the recording?
Yes.
Okay. And that you did that about 4 times, right?
I don't remember that, but I remember I didn't want.
I object to this. We agreed that anything about the camera was not going to be pursued in this case. They're just asking about it coming in the side door, going to be suggestive that he tried to influence the camera to be turned on. I came into this hearing thinking that was out of this case, and we stipulated that at the beginning.
Well, and count 3 is out. That's nothing that's being pursued. I'll just tell you from my perspective, I've noticed that there's some things that Judge Johnson is able to recall with clarity when it seems like all the synapses were firing. And then there are other things that are being explored, and the answer is that I don't remember anything about, or that was the alcohol talking. And that's something we're gonna need to work through.
I guess I don't hear the same inconsistencies that you're hearing.
Okay.
But I do know this, it is consistent. We didn't think we'd be addressing anything about that camera and being suggested to be turned off. The implication is clear. He wants you to believe, I'm a judge, turn your camera off. That's what the implication is. And I didn't think we were going to be dealing with that.
And just
Okay,
for the record,
and-
I'm not making that argument. And I think we discussed this previously. We were going to discuss the fact that he had enough conscience and knew that he was asking to turn the cameras off, but he never used his judicial position. And I'm not arguing that at all. Not once during this entire thing did Judge Johnson ever say, I'm a judge, treat me differently.
And the significance that I'm taking from this is exactly what you described, which is now all of a sudden someone is able to make that degree of sophisticated thinking of, this doesn't need to be on camera. Why don't you turn that camera off while we continue a conversation about which I remember nothing? I think we're entitled to explore that. If Mr. Boring's not going to ask it, I'm going to ask it. It's on my list of questions to ask. There's nothing to do with 1.3. There's nothing to do with count 3 that has been withdrawn from our consideration.
Like that old joke, Judge, if you're asking for him, I object. If you're asking for me, I withdraw the question.
Okay.
And I just will note it's in counts 1 and 2 as well, still not for the purposes of prestige.
Okay.
And I'll just be clear, you never at any time during that night, did you try to throw your judicial position into the mess that had happened at your house, correct?
Never.
Okay, as much as you remember.
Know he was a judge.
Oh, no. I'm not arguing that. I think that plays into a different analysis. But in that, Travis is not supposed to turn off his camera, and law enforcement is not supposed to do that when they investigate a case, right?
Well, honestly,
I don't know. You were a cop years ago, so it may have been
we
different.
didn't
back
have
then.
those. So I didn't know what, I know they can record and sometimes they don't. So I was like,
Right.
if you don't have to.
Mr. Hyde's very fond that they didn't have those cameras back up.
For Richard
I
Hyde.
said, thank God.
So,
But in any event.
No, I don't know that they can't turn them off. I know that now because he says, I can't do that. I remember that very specifically. And then
And that was going to be my next question. Yeah. And the reason you did this, from what I understand, is part of it is, obviously you didn't want it to be recorded. What was saying, and this was something you were pretty upset about and you're embarrassed about.
well, yeah. And I was embarrassed talking to Travis too, because that we've had a long relationship. Matter of fact, I introduced him to his current wife. And I don't know if he's still happy about that or not, but.
Yeah. And, and that's kind of one of the last, points I just wanted to make. Sheriff Terrell is a great sheriff. You've got great law enforcement up there, but you can't really distance the fact that you knew these people really well, right?
That's correct.
And Sheriff Terrell, I think y'all have known each other 35 years, something.
It's been a minute.
Did you work with him when you were in the sheriff's office initially?
I did.
Okay, I tried to do the math mentally. I wasn't sure. But so you've known them a long time, right? Okay. And they didn't call the GBI in to investigate it or anything like that.
No, but let me also clarify
Yeah.
something on that.
Mhm.
My understanding of our current sheriff's office is they're self-sufficient. They don't necessarily have to call the GBI for
Yeah,
assistance.
I don't think they have to in a
So let me
circumstance
also
like
say this.
Yeah.
You're right. I absolutely do know Sheriff Terrell. I know him as Joey. I know Lieutenant Gerald's. I know him as Travis, and the 2 younger deputies. I know of them, not like I know the older guys, but I know them also well enough to know too, that if they felt like they had probable cause, they're going to do the right thing.
Mhm.
And if they had arrested me, granted, I don't feel like I've committed a crime. And I think I may have said that on a couple of those videos, but the whole appearance of impropriety that goes along with this was all just, it's horrible. And I completely understand it. And I also want to say this very briefly, that I do recall certain things in pictures very vividly. My wife sitting in the driver's seat of the vehicle, me on the passenger side, pleading with her to get out. And I don't remember picking up the Swiffer, not saying I didn't pick up the Swiffer or whatever it was, but I was using my hand like, get out. Just like I would do on the bench if I was trying to return order to the courtroom. Like, listen, hey, listen, that kind of thing. in addition to that, there are certain parts of that that I remember very vividly, and there's a lot of stuff that I really don't. But I'm not denying any of it. I'm not denying this. I'm not arguing with you.
Right.
Except for the part about, I don't even tell people I'm a judge when I'm out in public. I mean, what do you do for a living? I usually tell them, and it's not a lie, that I'm an entertainer because I used to sing. And so, because I don't want to open that door. And that's just me though. Not that I'm not proud of my job, don't get me wrong, but it's just not something I go there.
All right. And I think I've covered the next question already, so just have 1 second, judges. That's all I have. Thank you.
Well, I was a country singer. And I wrote some of my own songs. I actually went to Nashville during part of my law enforcement career and made a recording of some of my original stuff and paid a production company to release a single. But two things I learned during that experience is you got to have talent. and it's really, really hard to do something productive with music unless you're in that position.
Is that it, Mr. Boring?
Yes, sorry.
No, I think you had said that, but Judge Lopez was exploring the response that might prompt even more questions than if you said you're a judge. You say you're an entertainer. If you're trying to slough someone off, they're not going to disappear when you say entertainer.
Well, that's
Safer to answer.
not in my community. When I was thinking about a time in Gatlinburg on the trolley when Laura and I were riding, and the guy said, "What do you do for a living?" And I said, "I'm an entertainer." So not my people,
All right.
my community.
Mr. Kathy, do you have any redirect? Okay, thank you, Judge Johnson. You can
All right,
step down.
thank you.
Yes, we're going to take a 5-minute transition break from Judge Johnson. The next witness will be Mr. Dr. Obst. Okay, and he's here. There he is, Dr. Obst. Great. All right, so in 5 minutes, we will see you up here, Dr. Obst.
On the stand if you want me to.
In 3 minutes, you can do that. Here.
Right, yes.
Yes, everything's great. Thank you. I remembered my magic touchscreen, and so we bounced back to, no one has used their plugin. It's just been the overhead projector. Right. Great. All good. Thank you. Yes. Sure. Richard Hyde, as in Jekyll and Robert McBurney. Robert. MCBURNEY. Yep. And then Dax, DAX, Lopez. You bet.
Vanani is with us too. I'll take it. You parked that this morning. Yeah, I was trying to hurry and get in here and unload. I'm like. Only like the last one, so I think it's 6 rounds. All we can is got two.
I read a news article about you not being the busiest man in the road.
Yeah, you can find anything in the media, I'm learning.
James Brown. Robe is not as colorful as James's
No.
cape, but Your Honor, if I can come up, I have one exhibit through him and it says CV. I'll bring them on up.
Okay, make that 14. Great. All right, why don't you have him come on up? CV of Dr. Or was. Yeah. He was dismissed. Need one. And the curve goes like this. Shh. Wait till you get to the nightstand demonstration. We need some diversity.
Yeah, unfortunately.
All right. Ms. Womble, are you ready? As always, let's get back on the record. We have the second witness from Judge Johnson's presentation. When you're ready, Mr. Kathy, why don't you you can swear the witness in and then he can introduce himself.
Would you raise your right hand, please? Do you swear the testimony you're about to give before this panel will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Would you state your name, please?
Yes, Robert Obst, O-B-S-T.
Do you have a profession, and could you tell us what it is?
I'm a clinical psychologist
And where is your practice?
on Lake Forest Drive in Sandy Springs,
How long have you been a licensed psychologist?
getting long in the tooth. 35, 37 years now.
I have just, before we went back on the record, presented Exhibit 14 to the panel members. And that's your CV, so they have your CV now to look at. I tender that exhibit, Your Honor.
No objection. I reviewed it.
Great. Exhibit 14 is admitted.
Dr. Opes, they have your CV, the panel does, but would you briefly give us your educational background and what brings you the ability to come here and give testimony?
Okay, my educational background, I went to Cornell College, got an undergraduate degree in psychology. Then I went to graduate school at the Illinois School of Professional Psychology in Chicago. I did some training at the Institute of Psychiatry in Northwestern University. After 3 years of graduate school, I completed an internship in Virginia at Portsmouth Psychiatric Center. After completing that finished my research and then came to Atlanta and began practicing. And basically, over the years, I have done a combination of psychotherapy and I've done many evaluations called many independent medical evaluations with a forensic psychiatrist. We did a lot of those, Dave Davis. And I've been in practice for many years with 3 psychiatrists and myself in the office. 2 of them have retired and now it's myself and 1 psychiatrist. And
So your practice had psychiatrists and psychologists within the practice.
right. And so, okay.
Now, tell me what your practice consists of today, your practice.
Probably about, right now, probably about 60, 70% is doing psychotherapy with adults, some adolescents, some children. At times I've done more of a different kind of balance where I've done more psychological and neuropsychological testing. I get referrals from, I've worked with the licensing board for the Bar Association for many years, the board to determine fitness, looking at law, people who are in law school, if they're having difficulties, they'd like evaluations. I've done some for the licensing board for physicians and corporations. I've done disability evaluations, many Social Security. So I spend some of the time, internists refer people mostly for maybe a diagnosis or for see if someone has dementia is fairly common. So I do these kind of evaluations, but most of my time is doing psychotherapy.
Have you done any experience, have you had any experience doing evaluations for physicians and surgeons?
Yes.
Tell us about that part of your practice.
Well, where it's relevant here, I've treated, as the doctor, many physicians who have been in treatment for substance abuse or chemical dependency issues. And basically in Georgia, there's a PHP program, PHP, Physicians Health Program, where they've, years back for substance and chemical dependence, there was a more punitive reaction. I'd say in the last 10, 15 years, their goal is really trying to develop a program that can protect the public for people with this problem and protect the doctor as well. And so it's a twin goals of the public and the doctor. So what happens when someone has been identified with having a problem with chemical dependency, they're referred for treatment. And it usually starts off with like with Judge Johnson did. There's an intervention, and then there's hospitalization and a safe detox and withdrawal from whatever they're, and then they enter the group and individual psychotherapy form, area of treatment. And for the people going through the PHP program, it's a number of years, 3 to 5 years. And it's been successful, probably 70%. I saw someone 3 weeks ago. I've been working with him. He's well known in his field. He was an infectious disease doctor, and he's 5 years of sobriety now. I saw someone else a couple of weeks ago, an urgent medicine doctor, and he was allowed to, he had skimmed medication, from people who would come in, they do narcotic counts, and he would take a few of those out, and he got addicted to some of the narcotics. But he went through this program and outpatient therapy, and he's practicing now as an urgent care doctor. And just, I was so impressed with the way they've treated physicians. It's a very tight program, but he saved someone's life last week. He told me that when he came in, he said it was an incredible day. But so I've seen many physicians and as well as attorneys having a chance to work, return to work and restore their professional functioning.
Now, you've been called upon by the State Bar, Georgia Board of Bar Examiners, to do fitness evaluations for the fitness committee of the Office of Bar Examiners.
Yes.
And I believe in the fitness program, some of the things that you look for or that you've dealt with in question of preparedness to take the bar are both substance abuse and mental or emotional instability. Is that correct?
Yes, personality disorders and things like that. Yeah.
And what do you do with those? How do you treat those people? How do you assess?
I spend many hours talking with them, getting a careful history, and then administer a battery of tests. Some are intellectually oriented tests that's looking at cognitive functioning, memory, and some are the personality tests. They're looking at psychodynamics of someone's personality, trying to understand character and fitness. Do they have, to me, it's always important with professionals, do they have a good superego or conscience? Do they have remorse? Have they been candid? Do they really care about what they've done? Do they really understand they've hurt a lot of people and maybe endangered people? And because at the beginning phases of treatment, sometimes people are a little bit hazy, they're cut off from their feelings because of the alcohol or the drugs. But what's important is that they feel it, emotionally what they've done, and they take it seriously. And they're very kind of like what Judge Johnson was doing, going to meetings every day. That's a lot of work, and individual therapy, and maybe marital treatment if they have marital issues. But it's an ongoing, they're working with a sponsor in addition to, say, with me in psychotherapy. But they really work hard.
Did you take some of the information and skills that you've learned through the PHP program and address it with your clients in other professions?
Yes, it's a general, I have a kind of a model that I think is most helpful. And
have you had physicians that you treated go back in the operating room and operate on people?
Yes.
After they were at least called into question with their substance abuse?
Yes, it's kind of amazing because years back when I was doing more evaluations at the psychiatric hospitals in Atlanta, there was the Impaired Professionals Program. It was kind of astounding because part of the intellectual examination would be the standard IQ test. And I would look at their functioning and verbal functioning or visual spatial, and I think, how in God's name do they practice? I mean, there were, like an average IQ. How did they get through whatever program they went through? But it was really amazing to see. And 6 months later, like retesting, all of a sudden they have superior IQs and their abstract thinking's there, their memory. They couldn't remember word pairs or lists of things that I presented to them.
Are you saying to the panel when they get sober,
Right.
clean, their cognitive aspects go up too? The IQ goes up?
Most definitely. The executive functions, that's an important part of, we all need a good executive function system. It's kind of like an umbrella term, but it has to do with like getting up in the morning, planning, what do I need to do, controlling impulses.
I've heard executive function referred to as your decision-making process.
Absolutely, yeah.
And controlling your inhibitions. Is that correct?
Yes.
Uh,
First, well, it's a story, never mind, go ahead.
Well, I'm often inarticulate in my questions. If you think you need to say something, we'll listen to it. Now, did you ever treat Gerald Johnson?
Yes, I did an assessment, not psychotherapy.
Before I get into that, how did you come to get referred by Mr. Johnson?
I think you had asked me to see him.
And how did I meet you?
Through working with some attorneys that had some problems. You were, I really have admired what you've done for some attorneys trying to help them out. And so they got treatment and then assessments.
I met you because you were referred, one of my clients was referred to you by the state bar for an evaluation, correct? The
Yes.
state bar chose you to look at my client.
Yes.
And that's how we met. And you've worked with some of my clients and a lot of other lawyers' clients, right?
Yes.
So what did you do with Judge Johnson? What were you asked to do about Judge Johnson?
Well, to assess his level of functioning, to make a diagnosis and make any kind of treatment recommendations.
Was one of the things you did to determine if he had any underlying psychological problems that would prevent him to returning to his normal activities if he remained sober? Just tell us about that.
Could you repeat? I don't quite understand that.
Did you do any evaluations on him? Tell us what kind of evaluations you did.
Okay, it was hours of interviewing, lots of questions, social history.
I think
looking
we
at-
said to the panel maybe, or that you spent 3 days with him testing him.
Yes, it did. Yeah, so it wasn't just one meeting. It
What
took
kind
many
of,
hours.
yeah, what kind of test? You actually performed recognized psychological testing on him.
Yes, like the Wechsler Intelligence Scale, the MMPI, the Rorschach test, the Thematic Apperception test, the Milan Clinical Multi-Axial Personality Test. So it was a pretty standard, but careful battery.
And what were you trying to determine with those tests?
Well, I wanted to understand what his emotional functioning was like, what kind of character, what his life was like before. Like I wanted to understand like was there an addiction there? And if so, how did that come about? What kind of effect did that have on him and his functioning? I was concerned too, one of the diagnoses, he related stories to me. He was a commander, a police officer, and he was involved in some very scary situations in which he said to me, there were some really dangerous people out there at meth labs that made threats to him and said, we're not going to let this score go. We're going to find you. We're going to get you. And he had dreams, like being, I'm sure everyone here has known or heard of PTSD, when that creates a lot of fear and anxiety. It can cause sleep disturbances and bad dreams. And so I was curious about to what effect is that affecting him? Did he have much anxiety? And what was his mood like? And what was his thinking like?
When he came to you, had he been already participating in alcoholism therapy?
He was just starting. He was just getting that started.
He had been to an inside facility, had he not?
Yes, he had gone to Blue Ridge Mountain Recovery Center.
What did you find his diagnosis to be relative to alcohol?
Alcohol use disorder.
Now, is that a recognized psychological disorder?
Yes.
And how is it recognized? By whom is it recognized?
By the American Psychiatric Association, has a manual really. It's called the DSM-5.
Diagnostic and Statistical Manual number 5.
Right.
And that recognizes his disorder.
Right. And they spell out criteria, that need to be met in order to warrant a diagnosis.
And had he already obtained that diagnosis from people he'd seen before?
I think so.
Isn't one of the things we ask you to do to assess what program he had been on and ask if that program had been appropriate for him?
Yes.
And what was your conclusion about that?
Yes, I thought it was a good program. I'd heard of it, and I think I talked to a couple of people who are familiar with it. And it was, I remember what he said. He said he remembered sitting there in the waiting room in the lobby, and he felt so ashamed, and that he had let so many people down. Here he was, a former policeman and a judge in this situation. But I was impressed with that because it showed guilt. It showed concern, and he thought maybe it was a black eye and he had hurt a lot of people and let people down. He wasn't, but he said he wanted to get better, and it was time to do that.
So what recommendations did you make to Judge Johnson?
I recommended that he continue, he completed that program at Blue Mountain for about a month, which is a fairly standard and a really good start. He was safely withdrawn from the alcohol. And then from there, he went to, he saw someone for individual therapy. Then he went over to Twin Lakes Recovery Program, which, again, he went right into, some people stop, they go through a month and they say, that's it. I'm done, I'm better. And he didn't. He wanted to continue on, with what was being recommended by people he was working with there. And they said, you need to go to 90 meetings in 90 days and also go to individual therapy. And he said he agreed to do that. And so I thought that Twin Lakes often also included going 3 hours a night for, I think, maybe a month, every other night. And so it was a week, so it was an outpatient program. So he graduated really from an inpatient intense program, and then moved into an outpatient program that has, 3 hours every other day and some individual therapy. And they're also including him in AA meetings to get the hang of going to meetings.
Had you been consulted by Judge Johnson back in October when this untoward event happened that got him restricted and leaving the bench? If you'd gotten to him then, what would your program have been? What would you have asked him to do?
That's a good question. I would have done, I couldn't have crafted a better program. And I was impressed that he did the whole thing. The only thing, I'm not sure if they were doing drug tests too at the programs. But, there was a good inpatient period of time of intensity, outpatients, individual therapy, and AA meetings. It was a very, very involved, very serious,
what would be the goal of your therapeutic program for Judge Johnson?
Clearly, it would be abstinence. And what's really important, a lot of people fail at this, and it's sad, but they think, okay, I'm better. I think I can just have a beer once in a while. I can have a drink, his goal, and I think that they emphasized this as well, was you can't do that. What's the old adage? A cucumber can't become a pickle again. You can't be a safe drinker. What happens is, drinking over time changes the circuitry of in the limbic system and the dopamine. And so basically, just without going into this in detail, but it's important, that when people drink, the dopamine in the pleasure center circuits in the brain, it causes pleasure. You enjoy it. And after a while, all the other pleasures that are out there in the world don't feel as pleasant. But alcohol is there, so you can use that to feel some pleasure as well as to calm anxiety. And so he was gradually drawn into that. But with recovery, when you stop drinking, those circuits get better. The executive functions start, getting stronger, your memory, your impulse control. If you think of having a drink, you think, no, I can't do that. Before, if I want to drink, I'll have a drink.
So it's your testimony that does alcohol affect one's executive functioning?
Yes, it seriously compromises it.
And you were familiar with somewhat, because of your history you took from your patients, of the events of the evening when the police came to his house?
Yes.
I think the panel wants to know, what role did alcohol play in that? If was this a breakdown of his executive function, in your opinion?
Yeah, it was a classic breakdown. There was because really the part of the executive function, and it's kind of it's the ability to think about an impulse, to think about what you're doing and correct your course, change direction. I can't do that. And his thinking was very blurry, and it was distorted that night, and his judgment was impaired. He wasn't thinking. The frontal cortex was not engaged anymore, like is well known with alcohol, what happens when people drink.
So would that event, in your opinion, have occurred without the ingestion of alcohol?
No, I really don't think that would. I think this is an important part about Judge Johnson. I think he's a very conscientious person. He cares a lot about people. He has empathy. He has a very strong conscience. He was raised with a strong emphasis on religion growing up, doing the right thing, being open and being honest. And he's not likely to be aggressive. And he's been more there. He's more of a self-sacrificing person, trying to help others, maybe at his own expense, but he's not an aggressive person by nature. He doesn't have, I don't think he's likely to get angry or be threatening with people. He's more like of a caring or kind of person in general.
Doctor, how do we explain that this kind, considerate, caring person that you just talked about actually pointed a weapon at somebody? That's hard for some of the members of the panel to process. Tell us how that happened with the breakdown of executive function and what role alcohol had to do with that.
Basically, that the executive function, there's no really capacity for self-observation at that point, like really thinking about what I'm doing. There was depression that night. He was on the verge of ending his life. When his wife, was not talking with him, in his mind, he thought, it's over. I've lost her. And he's been through a divorce in the past. And he thought it was difficult to bear the thought of losing her. So he was in a dark kind of like a undertow, and he was feeling like hopeless. And the alcohol certainly amplified that terrible feeling. So his judgment was very distorted, and his ability think about what he was doing, the right and wrong of it was really compromised.
During your evaluation of him, did you find any psychological condition that would prevent him from returning to work as a magistrate judge?
No, I didn't. I think he has the kind of character that I would like to see in a judge. I mean, the caring for people. Like when I talked to him about a month ago on the phone, I just checked in with him. He said that, this is what's happened to me. I'm a better person. I've gone through a lot, but he said I wouldn't, this would help me back in my position. He just spontaneously offered because maybe people who come into the court and have done things that were, dangerous or reckless or illegal, had substance issues. Maybe I could steer them in the right direction so they could get some help. That's the kind of person, I thought, that he's I think he's a kind and caring person.
Did Judge Johnson share with you prior situations in which alcohol interfered with his executive functioning, or prior situations when he was thinking about harming himself?
No, he said he had felt during the divorce in the past and some family problems, he felt some depression, but he never described he was on the verge of really wanting to end his life. I'm not sure what exactly.
So a lot of times in like work, we would do risk and needs assessment, high risk, low risk of your family. But if treatment would be level treatment. Significant supervision, or did they have a low need of treatment?
Yeah, I thought he was more of at that point, just given he was functional. Like I asked him, do you ever go on the bench? Were we ever drinking before work? He said, never. So that showed some good control. Did you ever get in any fights? None. Did you ever shout at people? Or did you ever try and harm yourself or someone? Did you drive when you were drinking? So he had that kind of control. He wasn't that, some people who are drinking more heavily, nightly, he wouldn't do it during the day, it would be in the evening. And so, it was kind of like, it was kind of like in control, but not healthy. I think he would do it to kind of calm down. It'd start off with a drink, couple drinks, 3 drinks a night. And some nights he would just have a couple drinks, maybe, but, he wasn't like binge drinking heavily or being really doing that nightly. I think what happened this particular night, that weekend, was a lot heavier, the drinking.
You talk to him periodically after the 3 days of testing, right? And the program he's on now is basically 12-step program, right?
Right.
And are you available to him, and do you talk to him occasionally?
Yes, I've checked in with him. I cared about him. And I said, if you ever need anything, call. And he said he would.
Is the counseling he's doing with his AA successful now? He's been sober how long? A year?
Yeah, it's a year.
Now, does that give you any indication about the success of permanent sobriety, the fact that he's been sober for a year? Is that significant?
No, that's really important. Like in the school you were describing, if you get to a year without any relapse, it's a really positive sign for recovery and being able to sustain
So
it.
past performance is maybe indicate future results.
Yeah, yeah. And I think with that too is the he has part of AA's magic is really, it's relationships. When we have a friend or people we're close to, we can talk about, or we can call, or you have that support around you with people. You're not alone. He's really involved in the AA. He's had people he's very close to there, and he's in therapy, So I think that, going a whole year, and his brain, the circuitry's changed. It's healed up. Those executive functions and the circuitry and the dopaminergic system, it changes over time. And like I was saying with the intellectual tests, you can just see them start blossoming. And some of the people I saw, attorneys, I know they were really bright to get to law school or doctors, they were like really not doing well at all in a lot of areas. Then to see them a year later, they were doing fine, like you could see them back to their own high level of functioning. So his brain is functioning well, his judgment, his impulse control. After a year, those things have been well restored, So plus he's got a support system. His wife is involved in this program and goes to meetings too. So they have that to share together, which it was really helpful to have a spouse who says, how are you doing? Or I'm not doing so well today. He could turn to her.
In your business, is codependency as to alcohol use between spouses detrimental?
Yeah, I don't know if they have codependence, but they're sharing this. They both are working, they're very open with each other.
I'm talking about before.
Oh,
The fact that they both consumed, was that detrimental to
yeah,
the
that was
relationship?
another thing that could help promote
The
drinking.
reverse is if they're both sober now and working together, does that have a synergy about their ability both to retain
Definitely,
sobriety?
definitely.
So are you saying it would be unlikely for him to do this?
I thought about that a lot, and I really think because I'm always thinking with people I'm working with, are they going to make it? Or what else has to be done to help them make it? Because if they didn't, really bad things can happen, maybe death. But I really think he has done so well and has constructed such a good program. I'd say he is very capable of making it and continuing his sobriety. He's very, you know him and you heard him. He's candid, he's open, he feels guilt, he's conscientious. He really cares about people, his profession. He's hardworking. My heart was a little bit broken when he came in. He wasn't working. He lost his position. He went working in a factory. He says, this is the right thing to do. And he was working nights.
But he was getting paid $90,000 a year.
I didn't know what that, but he went and worked, and I gave, my hat was off to him. It was not an easy job, but he went and worked. I thought there's a strong work ethic in him for doing that.
Well, I will ask you this question, which was a first cousin of Mr. Hyde's question. Do you believe to a reasonable degree of medical probability or psychological probability that Mr. Johnson will remain sober?
I think he has a good prognosis. No one can predict with 100% certainty, but he has all those things going in his favor. That he's genuinely committed to his sobriety. He told me how he feels so much better when he thinks about drinking. He said, like that feeling of even having a drink. It's not kind of romanticized. He's not missing it. He's not feeling cravings for it. Like it's a close call, but I didn't. I always ask my patients, if you ever feel close, call me. So they're at the Braves game. There's popcorn, peanuts, beer. I said, leave, come to the office. Don't stay there. Or people go into someone's medicine cabinets, make a call. Don't go in there.
Is your experience in the last year, has he been stressed at all or tempted at all?
He's very low, what he's told me is like, he's just not feeling like a craving or an urge or close call. He just feels like he's does not have that desire, which for some people, some people struggle a lot more. He's not one of those.
Have there been incidents that he's shared with you over the last year that could be viewed as significant enough stressors that there might be a temptation? Well, we see, I'm another accountability court judge like Judge Lopez. People who are sober for many months in the program, then there's a breakup in a relationship, or they lose their job, or get around the wrong people. It doesn't sound like for Judge Johnson it's the wrong people because he was a private drinker. but adversity hits. And then people revert to older ways and the defenses they thought they had in place weren't as strong. So my question to you, that exposition is, during your time with Judge Johnson, are you aware whether he encountered any significant moments of adversity such that there's been a test of his support network so that you could be more confident that if he's back on the bench and life gets difficult, there's a difficult case or he has a difficult colleague, or whatever, he would stay true to his professed commitment to sobriety?
I couldn't answer that, to be honest, like if there's been any really tests. He's gotten a lot.
You're not aware of it.
I'm not
You
aware
can't
of any.
answer it. You're either aware of them or you're not. You're saying you're not aware of a moment like that that Judge Johnson has encountered since he's been
It's a
working.
good question, but I'm just not aware of that to be able to answer that. I do think, on the flip side of that, I was impressed how he loved his job. And when you're doing something you really love, and it's meaningful, that you're more likely to be feel healthy and strong and have self-control.
Did he counsel with you about how the publicity had stressed him? And even with that publicity, he continued his sobriety.
Yeah, there's one thing. Yeah, he had the publicity was very painful to him.
But he didn't lose his sobriety.
No,
Now, you have had clients, especially physicians. You have a record of restoring people or helping people restore themselves to wellness and productivity. Have you not?
yes, I have.
Have you seen those people when they go back? How is the performance after the recovery and after their self-realization? How's the performance then versus before?
I would say that for what Judge Johnson has done, his performance would probably be better. He would be better judged today than he was a year ago. His performance and his functioning, his clarity is stronger. He's grown a lot as a person in this year. So I think he'd be better now. Rather than being riskier, I think he'd be better now. He's someone that's succeeded at this. Not everyone I see is so fortunate. It's a hard illness.
One of the things the panel is concerned about, I'm sure I would be were I there, is, well, we don't want to just send him back and base his testimony that I'm sober and his doctor's testimony that he's sober and I think he'll stay sober. You and I talked about during having a period of time, if he returns to the bench, where there are checks on him to make sure that there's security about that he is sober, not relying on your guess, your opinion and his testimony. And do you believe at a period of time, if he were to go back on the bench, where he could have testing?
Yes, I think that
You've had experience with that.
with the testing, and I'm working with several physicians now who, with the PHP program, who it's a random testing. You probably know this, but you call in for about a year, or it can go on for 2 years. You call in the morning, and if your number is 7362, you call on the phone, 7362 calling, you don't have to come in today to the lab to drop off something. Or you do have to come in, you have to do that within 24 hours. That is a very helpful thing. And I've asked people who have gotten to the 5-year mark or 3-year mark, what's really helped you here? Or was that helpful? It's good to know that it's there. One person, the one that I'm working with last week, said he had been golfing and someone got like a hole-in-one and he brought out a bottle he was carrying in his golf bag, and here, do you want a drink? And he almost had it. And he thought, no, but he knew he was being tested too. And I said, did that help you? And he said it did, because he could get called the next day, or he might not get called for 3 weeks, but I think it helps the public too. Like, okay, it keeps him safe. That is one more guardrail there that is really helpful. So I think for Judge Johnson, between 1, 2, or 3 years, whatever, like to be able to call in and just be able to do that is a really very helpful safeguard to keep him on the good path that he's on.
the people who you've helped, the ones that you've helped with counseling, some of them have had something other than an alcohol use disorder, alcohol abuse disorder. There's an alcohol dependence disorder. The DSM-5 changed the definitions of alcoholism between DSM-4 and DSM-5. Is that right?
Yes.
Tell us what the diagnosis of alcohol abuse disorder, what's the difference?
Well, it's really both have the central problem that it's, they both, there can be relapse and potential. And the problem when it becomes more of a dependence, you can have relapse, and even despite the heavy consequences, there's the next relapse and the next relapse. So there's a chronic relapse, with when there's regular drinking. The abuse is more occasional, like there could be a party, or your friends are drinking. And one person I was working with, he was in law school and he had quit for about 6 months. And then all of a sudden he went to a wedding, he was drinking, he just got carried away. And even his friend says, dude, we don't do that anymore, his college friends. But he got around that and that was a trigger for him,
Is the alcohol use disorder, the people diagnosed with alcohol abuse disorder, like Judge Johnson, have a better chance of retaining, maintaining sobriety than the ones with alcohol dependence disorder?
Absolutely, yeah.
His alcohol abuse is not as severe as the alcohol dependent.
Correct.
And you've made that determination by virtue of recognized testing.
Testing and just my experience over the years, people who have had daily use for long periods of time, their recovery is more difficult.
And how would you assess the recovery of Gerald Johnson?
I think he's made really fantastic recovery. He's been a whole year. There's not been one relapse. He goes to meetings. He feels positively about what he's done and how he's feeling. So, I think it's just done. It's been a lot of work when you think about it. It's easy in the courtroom to think, oh, go to meetings, but you get up, you go to the meeting, you go to individual therapy, you talk after the meeting. It takes up a lot of time, in your life to work on yourself like that.
How do you help people who go back to their job, say as a surgeon? How can people ever have confidence in that surgeon anymore? Since he's had a disorder that took him out of surgery and now he's back. What do you offer those people? How do you have your confidence back? How can you instill belief in you? What do you deal with those? What if they come back and say, nobody wants to come to me anymore?
Some people, doctors and attorneys, they don't say anything, and some have shared. So it's really a mixture of both. It was interesting when you were talking before, when Buzz Aldrin came down from the moon, and he was a rock star, right? And he had a Corvette. He was driving around and picking up women at bars. He was having a great time, in his words, right? And all of a sudden, though, here's this national hero, and he's really beside him, and he realized it was getting dangerous. And he told his father, I think he had been in the Navy, an admiral, he said, Dad, I got to get some help. He said, you can't do that. You're with NASA. You're an astronaut. He says, oh, yes, I am. He says, you can't do that. But he did, and he let it be known. And the public recognition that came from that was amazing, he said. He got so many calls and contacts and invitations to speak. But people, what I've seen is people, some people kind of, if you're open with it, they can be a little bit, cautious, like, can I trust this person, or is this person going to be okay? Or, it's inspiring to other people too. Well, if you did this, I can do this. Or I admire that you did this and that you're honest about it and you did something and you're doing fine now. And a lot of people are, they have that kind of trust. not everyone will have that, but I think a lot of people do.
Well, not everyone maybe will, but have you experienced in both your own experience and your training in the continuing ed you go to, that the attitude of the public is changing and recognizing addiction as an illness, which your profession recognizes, but is the lay people now beginning to realize that?
Oh, yeah, yeah. I think it's really widely known, like as an illness. There isn't the shame and the stigma that was there years ago.
Have you discussed with Judge Johnson his desire, once this is behind him, to be open and give speeches and gives talks and be counseling people?
Yeah, he was wondering, I think he mentioned that in the courtroom today, about doing something to help other people, like he was talking about the 12th step. And I think that's a nice
Do you
action.
think his returning to the bench would help him be a judge and be a more wholesome human being?
Yeah, I think he'd be a better judge now than a year before this.
Knowing
With
what-
all the, I think he's grown a lot.
knowing what you know about him, do you think his returning to the bench would be a harm to the public?
I don't think so. And I'm not trying to be, like, oh, I like him or anything. It's just objectively, he has a lot of the qualities that are prognostically favorable and, and indications that he could do well. And I like the safeguard. He's going to meetings. What happens in these programs, there's a binding contract. If you fail, this is what happens instantly, and they know that you've lost your license, or we were going to report you to a licensing board, something like that. But there's a lot of protection built in. He has a good support system. He's feeling better than he's felt with his mood. He's in secure relationships, and he loves his job. It's one of the things he told me when I first met him. I love my job, and I think, I think he's someone that I think you could take this kind of risk for. I think he could do well. That was like the goal of a lot of the programs, wanting to get people back to restore their professional functioning. Your life isn't over. This was a problem, an illness that you had. And now, you can control it. You're not caught up in it.
That's all I have. Thank you, Doc.
Mr. Kathy. Mr. Boring, questions for Dr. Obst?
Yes, Judge. Good afternoon.
Hello.
You talked to us a little bit about, I guess, the evening where this incident happened. What information did you have about this case? Where did you get your information?
From him.
From him. Did you have the video camera, audio camera recordings or anything like that?
No, I didn't.
Police reports?
No.
Didn't speak with any witnesses or anything like that?
No.
Okay, and you're talking with Judge Johnson months after the actual incident, correct?
Correct.
Okay. So obviously you weren't there that night.
Correct.
Okay. And I really do honestly appreciate everything you've done with Judge Johnson and what he's done to try to get help. But you're probably unfamiliar with this type of setting. You understand that a big part of why we're here is not necessarily the recovery and his alcoholism. It's the acts that happened on the night of October 18th, 2021.
Yes.
Okay. And I know you've represented doctors and lawyers. Have you represented judges before?
No.
Any of the attorneys or law students that you represent, have any of them ever?
There was one judge. Okay.
Okay, I'm sorry. I'm not asking for names,
Okay,
so
right,
cut that
okay.
off before you say something. So,
And I just want to understand the term. You're saying represent. You're treating.
Yes,
treating.
treating.
Okay.
Sorry,
Thank you.
wrong
That's
term.
right. Different profession.
Yes. So you're treating these people. Are any of them ever have they ever come to you or been referred to you because they pulled a firearm on a law enforcement officer?
No.
Do you ever deal with the criminal justice system? Do you evaluate people charged with crimes?
Yes.
Okay. And how much of your practice do you do with that?
Not a lot. Not,
Okay.
I was involved in a murder case a while back, but it's not too much.
mostly what you're doing is with doctors and lawyers, and treating them. A lot of times it's dealing with their licensure, correct? Or may that come into play?
It comes into play. Yep.
Are you familiar with the fact that there's a different standard for a judge as opposed to a lawyer at higher ethical standards that they have to abide by?
Yes.
Okay. Are you familiar with the Code of Judicial Conduct or their requirements or aspirations or anything like that?
I never read that, but I'd like to. Yeah.
Well,
You don't.
no, you don't. No.
One of the grounds for us to sanction someone is habitual intemperance. Is there any evidence that you've seen? Habitual intemperance.
I didn't get that sense that he displayed that. It's a good term for it, yeah.
Do you think, let's say,
I think it's pretty good natured and easygoing, like you heard him talking about music and singing, and I think he's a pretty more of a good natured person than intemperate or grumpy or irritable. He's more on the other side.
and so all those actions that I know you talked about, you gave an opinion as to what you thought was in his head that night. That's all based on what he's told you, correct?
Yes.
Okay. And you're not in here saying, I think you're saying the opposite of it, that there's no incapacitation issue here. Like he is not incapacitated to where he could not serve on the bench. You're actually saying that he would be able to function fully.
Yes.
You talked about there not being any, I guess there were different scenarios about reckless activity while drinking, not driving while he was drunk, things of that nature. And you would agree that walking around with an AR-15 highly intoxicated is a pretty reckless act.
Yes.
Okay. That's all I have. Thank you.
All right. Mr. Kathy, any redirect?
Nothing, Your Honor. I want to put in the record. In my binder, there are 2 letters of character reference. One from
Can Dr. Opes step down, or is he going to be a vehicle through which you?
Dr. Oakes, that's very rude of me. I do not have any more questions. You
Okay.
look so normal and part of the group. I just wanted you to stay here to hear it.
Thank you.
You can step down. You've been very kind. to come.
Thank you.
Thank you, sir.
3 judges. That was nice to be like such company. Thank you.
All right.
Okay.
Many thanks. Okay. Your Honor, we have 2 character letters. Once again, this is by agreement. Mr. Boring said he didn't mind those. Rather than, you could probably guess we could put a lot of character witnesses in the courthouse. But I have another letter to put in. It's just a statement. It prevented the sheriff from having to come. We stipulated what his testimony would be. And I'll just put it in I'll read it into the record.
All right.
We stipulated this, and I'll put it in evidence.
So this will be exhibit 15 when we get it. Okay.
The statement of Sheriff Joy Terrell. I have been familiar with Gerald Johnson for 35 years. I am familiar with his reputation in the community. I'm familiar with his reputation as a judge. His reputation for both was outstanding. I would believe him under oath. The Habersham County Sheriff's Office investigation revealed no criminal activity, but indicated a mental health issue. I notified the JQC and requested their assistance.
Okay.
I have a question.
Yes.
Are you done?
Yeah.
The letter from the county attorney, were you offering it as a character letter?
Yeah, it was.
Well,
So it's
first-
exhibit 11. So we're talking about the same thing.
Because the first paragraph, he's complaining about having to pay Judge Johnson for not working, is the way I read it.
I find the Supreme Court wants to, more is more with the Supreme Court, more is not less. And that's what the county attorney said. I think if you want to know the truth, Mr. Hyde, I think it was intended as a criticism for the process taking so long. That's what I really.
That's how I read it.
Noted.
And that can't be helped. I'm often the messenger on that, but it's, I think, well, anyway.
Well, that bill is the least of our sins in terms
Uh,
of people getting paid while they're not working.
And that unfortunately happens. And they shouldn't be punished for that. I hope he won't be. Thank you. We rest now.
All right. Any rebuttal, Mr. Boring?
No, Judge.
Why don't we give you all about 5 minutes and then, Mr. Boring, you're going to make whatever argument you're going to make, and then we'll hear from Mr. Kathy, or you.
I'll just wait and let him go first.
All right. So in about 5 minutes, Mr. Kathy or Mr. Harkness, we'll be happy to hear your argument as to not so much what's been shown, although I guess that there's been evidence. I don't mean to suggest there wasn't evidence, but again, I don't think the debate here is what happened. It is maybe why it happened, but more importantly, what ought to happen going
I've
forward.
argued so much already, I might not have.
That's okay. We have processed what you shared, but I think that's a fair assessment.
I would still love to hear an acceptable suggested sanction other than the one if you have one, if you can think of one in 5 minutes, other than the suspension as you laid it out.
Well, there's your project. We'll see you in 4.
Only reason why I've done something is.
it's going to be the Supreme.
What is?
That one.
Ms. Wamble, you ready? Great, you all can be seated. Mr. Kathy, before you get started, the other panel members and I were processing everything you all have shared with us today, and what we've been reading. And we are going to share with you a perspective we've begun to develop. It's not finalized, but it could streamline some of the work that collectively we need to do. And it may be something that you want to pause and discuss between the two sides before you make your arguments. And this is the notion, and it relates to sanction, because I don't think it's disputed that, in fact, he's admitted, the judge has, that he's violated the different rules of the canons that were identified. But what we've discussed is a sanction that would consist of a suspension without pay for the duration of Judge Johnson's term, so that he would be free to seek the approval of his constituency and make the case that he ought to be returned to office when his seat is open. It would relieve the county of the financial burden of paying someone who's very able to do the work, but wouldn't be permitted to do the work because of a suspension. But it would also address the concern that the panel members have shared with each other, that the recommendation that you've set forth in the unsigned discipline by consent, which is in effect shorthand from us, you've already had your sanction and you can get back to work now. You had a paid sanction. There was certainly a stigma attached, and no one is minimizing that. But I think Mr. Hyde made it pretty clear, and I think Judge Lopez and I second that perspective, that's insufficient based on what we perceive the conduct to have been and the seriousness of that conduct. And so this is tentative from us. I don't know that this is what we would recommend in the end, but it struck a chord with the three of us. And then we thought, if that's something that everyone agreed on, then it could end up being a discipline by consent, which flows through the process more rapidly than what would happen if there's not a meeting of the minds, and there doesn't need to be. I'm not applying any pressure here at all, but then we'd have to take things under advisement, draft an R&R, circulate that draft amongst the three of us, et cetera. So that may be something that seems underwhelming to the director, and it may seem overwhelming to Judge Johnson and his lawyers, and that's perfectly understandable. And it may just be too much too soon, but we thought about it enough and thought it wouldn't hurt to lob that out to the two sides. And you may say, well, let's at least huddle for 5 minutes, because we know our closing arguments are short enough that we don't need an hour and a half collectively to present them. So let me know what you'd like to do. We're fine and ready to start taking notes on the summations that you were prepared. But I know one of the assignments that Mr. Hyde had left Mr. Kathy was, we'll come up with something different, presumably more severe. And this is what we came up with as we huddle.
hybrid of what I came with.
Okay,
And look at Rule 23.
I'm looking at it.
okay. So, do you all want to talk about that for a minute, or do you already know out of hand that it is sufficiently uninteresting? We don't need to spend
I
time
want to
talking.
speak with Ms. Deal, if that's okay for a second. I may have a game plan that. Give me 5 minutes.
Sure, not a problem. We're going to step back out.
I would miss Field.
Well, one with her, 4 with you.
So we'll be back.
I'm gonna limit my minutes now. feel like an administrator.
Yeah.
Yes, sir. Will do. Thank you. Have a good one. Appreciate that.
Yes, sir.
Did you? Oh, okay. Yeah.
Dennis.
What would come to order?
You all can be seated. Ms. Womble, you ready? All right. So perhaps to some surprise, when we returned from our last break, instead of receiving information, we shared information and asked you all to think about it a little bit. No pressure. It may be, like I said, that's too much too soon, and we want to make our argument and take it from there. You're the one standing, Mr. Boring, so tell me what the director's perspective is on this.
Judge, my suggestion was, we actually have an investigative panel meeting Friday, was to possibly delay until after that meeting so I can run it by them. And if we were to do that, to delay closing arguments and just do that via brief within a week, maybe the Monday after Thanksgiving or earlier, I don't think they are amenable to, they don't feel the need to talk about it any further. So I don't think we need to go to the IP because I don't think they're amenable to it. That makes sense.
Got it. Meaning your idea of taking it to the IP is not because you all had reached a tentative understanding that that might be acceptable. It was, that's what
I
we.
do think, I think it was something that the investigative panel may accept, but I don't believe it's, they're going to accept it, whether it's 2 days, 5 days, 10 days.
Sure.
So,
Got it. Because that would be by consent.
correct.
Okay. Then Mr. Kathy, when you are ready.
First of all, I appreciate some consideration being given to not removal. But as we all know, that's tantamount to removal. For him to be removed until the election, 20 months from now, whatever it is. If I understood the suggested proposal was that Judge Johnson be suspended until his election in May of 24.
Whenever the election is.
May of 24. And during this period of time, he will not be paid and he will be a judge suspended. In effect, that's a removal. It really is, because I don't predict elections, but it would be hard for me to believe he could be reelected. By the same token, something could be done. I'm suggesting what I was going to suggest. It's been, the main problem we've got is we need a judge. And it's going to be hard to get a judge with Judge Johnson there like a Damocles sword ready to run again. We don't have the money. He's being paid. We owe a duty. He feels a great deal of loyalty to that system, to that magistrate court. Most of the pressure has been on him is that he's getting paid, hardly a vacation, but that's the term that's been used, while he's not working. We need a judge. And my suggestion of a hybrid, I said, was to suspend him for an additional 6 months without pay. Now, he has then been suspended for 12 months. He's going to be suspended another 6 months without pay. That's a financial burden on him. It is a recognition that his conduct doesn't justify removal because of mitigation. So that's something I think that that would give the pressure of the fiscal stuff in the county would be off. The overworked deputy magistrate would have her help back. Judge Johnson would have time to prove himself worthy. And I think the term when he goes back after that 6 months would contain random drug alcohol testing, mandatory reporting by a therapist who sees him to the JQC panel. And that accomplishes a lot here. It certainly recognizes that we can't have this conduct. 12 months before recognizes that, 6 additional months. Our county then has the comfort that we're going to have a judge back in 6 months. And that's not nothing. That we're up there and it's intense. It lets our deputy know. And one of the good parts about it is it's the good and the bad. It's during the holidays and a lot of the employees are off, but it's a good time. He'll come back in 6 months, whatever that will be. By the time that I don't know the time frame of when the Supreme Court gets this and how long it takes them to approve what you do.
I don't either.
You don't
I
know.
mean, I know that the panel has some control over when something arrives at the Supreme Court.
Oh, you do?
After that,
Well,
It's a consent.
I'll draw the consent order so you can, if you speed things up. Yeah.
I don't agree that he couldn't get reelected. I think he's.
Well, of course,
I know
anything's
that
possible.
circuit probably better than any circuit I've worked in. I think he could get elected. But did I hear you right saying that you don't think he can get reelected? And what's the argument for him to stay a judge if you're saying to us he can't get, his bosses won't hire him again? Why would they want him to stay on now? Help me with that.
I don't understand the question, frankly. If he's out of commission for another, he's been gone 2 years and he's been sanctioned. Somebody runs against him and said, look at this judge. Look what he's done. He's been sanctioned. He's been publicly reprimanded. He's been suspended.
They do that anyway.
Yeah, they can, but the difference is, the main difference is we will then have a judge in position and we don't have any pressure in that magistrate court. And that means something to my county.
Who's been filling in?
Magistrates from around.
If I may,
Yeah.
the county had allotted 12 hours of time to hire someone to come in and help. Then another magistrate judge had offered their time from another county. That judge can't be paid because they're a chief judge in another county. They're offering that time for free. So the one deputy magistrate we have has had a lot of put on her, a lot of 24-hour kind of calls, having to wait on warrants.
Well, I mean, the probate judge can fill in and you got some Superior Court judges up there that can fill in.
It's all a matter of pay. And
You
you know,
don't have to pay those three. They're
Well,
getting that. It'd be illegal to pay.
I don't know if you can hire a senior judge to do any of it
You certainly can.
without pay.
Sure.
Well, I don't know I don't know the inside. I know that I think I know a little bit about the politics there in my county.
I'm sure you do. And you can understand also that
Absolutely.
what we weigh isn't so much what inconveniences the Habersham County government more or less, as opposed to protecting the institution of the judgeship, the reputation of the judgeship, the integrity of the judgeship. So we're not ignoring the concern you flagged, but I don't know that what would be motivating much of the hearing panel's decision-making is the administrative needs of that jurisdiction. I don't, like you,
I don't believe it should be motivated.
okay,
But I'm telling you the realities of what we're living with.
understood.
But your motivation should be doing the right thing, considering whatever the rules say, all the facts and circumstances. And we can't find a precedent like this. There's not one. And really, if Gerald Johnson had stayed at his mother's house when he went down there, we wouldn't be here. Because every event happened before he was carried to his mother's house. Every event happened. And this is down to like 3 or 4 hours of the man's life. And my criminal lawyer tells me there's a significant difference between protecting your castle, opening your door with a weapon, than firing a weapon at somebody, because then it becomes, it's a whole different legal question then. And so he could open the door to his home with his weapon. He could do that. So, and it's easy to jump, well, what if you'd shot him? Well, of course that's different. Of course that's different. But all right, I'll say, I want to call into, I don't have to remind y'all about this, but you should use a reasonable and reasoned application of the code, or your rules, taking into account such factors as seriousness of the transgression. I think that's the only one of you take into consideration here, because there's not a pattern of improper activity. That's the next one. The effect of improper activities on the others are the judicial system. Only his reputation, repute. That's what this is. We're down to canon 1. That's what this is. It's what's his repute in the community. That's it. His reputation is destroyed. And in your panel and the Supreme Court, we're Potter Stewart-esque here. What is the disrepute? What is that? We don't know. We know this, disrepute can be rehabilitated. It can be changed. And that's what we think our judge has done. And so all I can do is present to this panel evidence. We presented his evidence where he's testified he didn't back down from the thing. From the day they walked in up there, the sheriff, anybody else, told exactly. And then I use testimony from the only professional testimony we got in the case is Dr. Obst. So I ask you, if my machine is on, I ask you to consider in mitigation, and once again, we don't have much guidance in mitigation with JQC. It's whatever this panel and the Supreme say is mitigation. You've read the cases. Well, this judge got reelected again, so that's mitigation. Is that really mitigation? Come on. But show me if my screen on, Your Honor.
Is about to be.
Okay. So what I do, I try to use the evidence that exists in disciplinary matters. And so I go to the good old ABA about mitigation factors for lawyers, and that's the closest we got. And here we go. Absence of a prior disciplinary record, we certainly got that. Absence of a dishonest or selfish motive, aberrant motive, selfish, dishonest, personal or emotional problems, that's mitigation now. And we've got that. Timely good faith effort to rectify the consequences of misconduct immediately. He didn't run from it. Full and free disclosure. I can't imagine anybody disclosing any more than he did disclosed. They got into the bedroom with him and talking about his situation. Other factors, character or reputation. This is a good man. Everybody says that. Even the newspaper wrote articles about him, talked about what a good person he was. Mental disability or chemical dependency, including alcoholism. It's in their mitigation circumstances. And abuse when there's medical evidence that the respondent is affected by the chemical dependence. We had that. Y'all just heard it. The chemical dependency caused the misconduct. You heard about the breakdown of executive function caused by the alcohol use. The respondent's recovery from the chemical agents or mental is documented or demonstrated by a meaningful and a sustained period. We're talking a year. We're in our 13th month of sobriety. And finally, remorse. You don't have to hear this man pour his heart out about how he's devastated by what he's done. All right, now we heard the testimony about the rehabilitation actions taken by him to mitigate this punishment. And here it is. He, subsequent to the suspension, he immediately went counsel with a counselor. She recommended a great recovery program. You heard Dr. Opes, he's familiar with it. He went into then a 90-day and intensive outpatient, and he's continued his treatment at the conclusion of the Twin Lakes. He had meetings. I don't know how anybody could have done more than this man has done to say, I'm whole again and I'm wholesome again. I don't see how anybody could have done any more. Now, here's alcohol use disorder, which is what we know he has been assessed with. His component of that is the abuse disorder. And we've heard it, we know it was diagnosed. It's a recognized DSM diagnosis. The psych evaluations confirm there's no underlying problems that'll affect him if he's sober. It's important that an incapacity not be treated as misconduct. And willful conduct should be clearly distinguished from conduct that's beyond the control of the judge. And his only testimony we have is that this alcohol made it beyond his control. That's what testimony we have. Now, we can all speculate and say that's not true, but that's the record. And his executive function can be adversely affected by alcohol. And importantly for me, this disorder is diagnosed as a disease, but a treatable one by the ABA. So we're back to what is the right thing to do. And I appreciate the consideration of not taking the robe and saying, well, we're going to suspend him. That is a nice way of disrobing him without saying it. That's really what it is. And I'm appreciative that the panel will consider not removal from the bench, but that is removal, tantamount to removal. And it benefits him, not any. It does no more, I don't think, for our public image of sanctioning judges for misconduct than another action to say, okay, we're going to suspend you 6 more months because of these factors. You mitigated it pretty good, so we're going to give you 6 months without pay. And when you come back to work, you're going to be working for the county and you're going to have supervision. You're going to have to do this and that and the other. Now, whoever runs against him will use those things against him, and we know that. But he will at least have the chance to prove to people my rehabilitation is complete. I'm a whole man again. I'm a better judge than I was then because I did something to control my life. I saved my life and my marriage. And I think Gerald is right. I think when Sheriff Joey Terrell called the JQC, it was a blessing in disguise. But let's complete that blessing. Let's ratify to him. Let's ratify. Judge, you're an example. You're an example to people. Come to the JQC, lay your heart out, do your job, and you might be able to save your reputation and your position as a judge. What's the downside to us putting him back in 6 months with conditions? What's the downside to it? You've told the public, we don't condone this. We're sanctioning him. And we're told the public, this is how you keep from getting disrobed. Do what this man did.
That's the messages you're sending. And unfortunately, everything we do is a precedent setter in this situation. And I think, I may be wrong, I think the Supreme Court would look kindly at somebody who's worked this hard. And I hope this panel will as well. Thank you, Your Honor.
Thank you, Mr. Kathy.
Good afternoon for one last time. You know, it's interesting when we were talking a lot about when this began kind of going off the onto a tangent about Habersham County and what they've suffered financially and that type of thing. And I think what this all keeps going back and what we keep losing sight of is why we're here. You know, we're not here because of that. Those actions were, and the reason for that is because of Mr. Johnson's actions. We're not here because somebody, you know, the JQC is trying to punish a judge for coming to us or coming to somebody for help for suffering through problems with substance abuse. I know a lot of attorneys, a lot of judges go through that. Absolutely not. What we're here for are the actions of what happened on October 18th, 2021, and how do we deal with that in the context of this position that the Judge Johnson held or holds, a magistrate court judge, a judicial officer, not an attorney, you know, not a doctor. This is somebody who has a higher calling and there's higher ethical standards that they have to abide by. You know, we aren't here to decide if somebody should be incarcerated or not. No, we've talked a lot about, you know, I guess, rehabilitation, that type of thing. We've heard the terms probation thrown out. We're not here to decide that. The goal of JQC proceedings and the purpose is broader than like a criminal sentencing type of hearing. Not only are we trying to hold somebody responsible for what they've done, but it's to repair damage done to the public trust, provide guidance to members of the judiciary, and make sure the public has confidence that we are holding people accountable and having people that are qualified as judges sit. And I think it's laudable what Judge Johnson has done as far as the attempts that he has gone through to try to get the help he needs to try to better his life. However, you know, courtrooms around the state and around this state and around Cobb County and Fulton County are littered with mental health courts. And in those cases, people are held accountable. They're not just, you know, it's not washed aside. They still have to go through A, B, and C and do these things, and they're punished. But this is a different animal. If the public thinks that a judge can be treated differently than the public is, that trust is destroyed. And we can talk all day about whether, you know, he was arrested or not. We know he was not arrested. And like I said, Sheriff Terrell is a great sheriff, got good law enforcement up there, but it's like, for instance, if the shoe were on the other foot in this case, could Judge Johnson ever have sat as a judge and been objective to hear a case involving his lifelong friend coming before him as a defendant? He would have had to recuse in a heartbeat on that. And so that's kind of what we're left here. I'm sure there are all the best intentions, but objectively, you as the hearing panel sitting there are looking at the facts in this case. And it's obvious that he violated the law 6 ways from Sunday that night. Before you, our purpose is not in here to try to prove criminal acts. We have a different purpose as well. We have to show that he violated the law for Rule 1.1 purposes, but we have to protect the public here. There's no doubt that Judge Johnson, nothing in this courtroom's come out, aside from the night in question, that he has good character. But the good character in this case does not undo the judge's behavior on that evening and how that impacts his ability and the public's perception of him sitting on the bench as a magistrate judge in Habersham County. He adjudicates the very types of cases that come before him involving acts very similar to that which he committed.
Talk to us a little bit
yes.
about that, just because the role is different from what I regularly experienced or Judge Lopez did. You use the verb adjudicate and yes, with small claims, but on the criminal side, for example, it doesn't sound like Judge Johnson would be presiding over a trial involving DUI or someone who
Right.
But what's an example, as you understand it, of where there would be decision-making, there need to be adjudication
At the,
that is
yes.
impacted by the public's perception that, wait a minute, here's someone who had an issue with alcohol and firearms and maybe domestic violence, and now he's back on the bench, and there was no arrest, no jail time, nothing, and now I'm in front of him.
At the very basic level, he is the one who determines whether to sign off on arrest warrants. You have search warrants. He is the gatekeeper with probable cause hearing. Is there probable cause at a probable cause hearing to set bonds for people? A myriad of things that the magistrate judge deals with on a day-to-day basis in the criminal sector.
What would you suggest as a sanction?
Honestly, this is a very difficult situation because, you know, even through this process, getting to know Judge Johnson to the degree we can from here. Unfortunately, I look at it and I have to look at it from our perspective of mine as a director. I don't think he can stay as a judge. I think that he has done a lot to show that he has grown and he can find a livelihood outside of this. But I think the damage has been too great to the public's perception and to his ability to be able to be a magistrate with the same detectives, the same types of acts coming in front of him. I feel like I think that objectively speaking, he just can't do it. And, you know, sometimes people, they make mistakes and they can redeem themselves and they can rehabilitate themselves. But you know what? They can't keep on doing the job that they did before because of they had a bad day, they had committed a bad act. And in this case, one of the factors you consider, the three that the Supreme Court have in our rules, very wide ranging, I would say. Seriousness of the transgression, whether there's a pattern of improper activity and the effect of the improper activity on others on the judicial system or on the judicial system. The two of those three, the seriousness of this occasion, that's why we don't have any precedent on this. This isn't like a case maybe in the past we've investigated with a DUI with a judge, something like that. I mean, you know, Mr. Hyde's been doing this before I was probably riding a bike, and he's seen everything. And what we haven't seen is a judge pulling an AR-15 and pointing it at a deputy.
The court give us some instruction though a few months ago, and are we, to what extent, if any, are we bound?
By which part? The
I forget the case, they run together.
oh, that, and you know,
You got a 50 gram from them.
yes, I think that as far as the factors to be considered, I think we have to be.
It was a
Yes.
pattern.
The pattern, and we have that from the Judge Hayes case. And then we also have a Judge Gundy case. We have two dueling ones, and we have Judge Hayes where it was a one-time occasion and he had a sparkling record. He's a 78-year-old man, magistrate judge who'd been a helicopter war pilot. And he lost his temper because he was getting dog cussed by an inmate and he pushed the inmate up against the wall. They found in that case, while, you know, he had a sparkling career and it was a momentary lapse in judgment, he still had to be suspended 30 days. This is far afield of that, in my opinion. You have the judge's actions here with a firearm. He knows better. He's drunk with an AR-15, popping off rounds in the backyard. He's breaking his wife's windshield. He's throwing stuff around the house.
It's easy to describe it as a one-off event, but it actually is a series. It's a composite event over time, not weeks, months, years, but unlike Judge Hayes, where it was literally 30 seconds, snap, I did less than 30 seconds. You can see it. We have a situation here where it was hours.
Yes.
And that's different, again, from on this day, and then again, a few days late, like maybe you were going to say with the Judge Gundy situation.
Right.
But then we also are bound to a certain extent by what the court does and what this panel has done in the past, even those of us that are disqualified on a certain case. You have a case where a judge, you could argue a judge may have committed a felony that gets a public reprimand. So
I'm aware of.
How do we deal with that?
And I think in that you look at what was the possible injury in that case, and we have, you know, obviously in the one case where there was arguably a false imprisonment.
I'm talking about a specific case.
Yes,
I'm
but
saying in general.
when we've had that in general, yes. I mean, I think in this case, the firearm takes it to a whole new level, and there's actual, not just the threat of okay, could this be a false imprisonment? Is this a simple assault? This is something outside the bounds of anything our agency's seen. Plus, it is public and it's been public. And it is something where the very cases that he's been involved with and has to be involved with in his job are the same types of people that are going to be coming before him. You're going to have defendants who are drunk and have committed crimes. And they're going to be like, hey, it was an excuse for you and you didn't even get you got to stay a judge. It's basically, I've written it down somewhere. Yeah.
Would you agree that he's okay to answer the door with a weapon in his own home when there is a knock or a noise?
A doorbell. Yes. Yeah. I would say he can answer it with the gun. When he points the gun at law enforcement and says, I didn't call no law.
But is the record that we have clear that he actually pointed the barrel of that weapon at
Yes.
an individual?
I don't think it's stipulated that he pointed the gun at Travis and said, I didn't call the law.
Which says to me, there was recognition that it was
Absolutely.
law enforcement, followed very closely. I credit
Mhm.
Judge Johnson's testimony. Whoops.
Yes.
I know that guy. He's running away. I've done something look at this gun. So I think both
Yeah.
pieces are there. Troubling for us would be the first piece.
Right. Yeah, absolutely. And so, yes, I think you can do that, but you couple that. The problem here is too, if he were sober and did exactly that, he wouldn't have pointed the gun at law enforcement. There wouldn't even been this issue. He probably would have looked out the window. He probably would have looked through the keyhole. He would have said, who's there? But because he put himself in that situation, drunk to a point he's thinking about committing suicide, he has done that and committed beyond a reckless act to bring himself to that situation. So it's not your normal, I'm protecting my castle. I've already raised a ruckus with my wife, started shooting guns off in a residential neighborhood where there's a store close enough I can hear laughter. It's apples and oranges to a degree. And the point's well taken as far as, can you do that in a general sense? Based on these facts, heck no, he couldn't have done that. And he shouldn't have done that. And because he did that, that's why we are here. And, I've said to many people over the course of the time I've been in this job, it is a weird job. It may be. And you have to deal with just some of the most difficult situations and the difficult, decisions that y'all are going to have to make. What the heck do we recommend in this case? And I just think because of the facts here, and what happened, because of the damage to the public trust and the lack of public confidence they will have for Judge Johnson as a magistrate judge, maybe not everybody, because a lot of people do know his character and would be able to parse out what happened that night with his rehabilitation and what he was before. But there's going to be a sector of the public that's going to have that. There's going to be that appearance of impropriety. Every time a sheriff's office person comes into the courtroom where he is, you're going to have a criminal defendant that may think, I'm not going to get a fair shake because, they're friendly. And objectively speaking, that's probably, or subjectively speaking, probably not, it's not the truth. I think Judge Johnson would try to do his job absolutely above board, but that's not the test. And that's what we struggle with. I know Ms. Veal and I do, is when we see good people that are in this situation, how do you handle the different mitigating and aggravating circumstances? And unfortunately, Dennis and I have been talking for a year now about how to resolve this. And it just has always come back to, the investigative panel and, us, we think this is the appropriate resolution, unfortunately.
This meeting
The removal from office. Yes, sir.
He's being judged on the worst 15 minutes of his life.
Sure is. However long. Yes, absolutely. Yep. And that's unfortunate, but sometimes you have to look at the spectrum of what's happened. And if it were something where, there was a different type of act with different circumstances, of course, we would look at, what has he done, the rehabilitation, which we have done. And that's what makes it so difficult to stand here and ask you all to approve of our recommendation. But, I was told early on when I took this job, it ain't an easy one. And sometimes you have to take tough positions and make tough decisions. And so that's the decision that the director, that I'm speaking in third person, that our agency has made and that we're going to hold to at this point. Thank you.
So we will take all this under advisement, as has been the case in the past, and this will be the first with this composition of the panel. So I'll let my co-panelists know. If we have questions or need more information, we'll reach out to both sides. It may be that we want more information from Judge Johnson's side, but we'll certainly let Director Boring and Deputy Director Veal know we're asking question X. No one needs to brief anything now, again, unless we have a question about something. Usually we don't require briefing. It's just, could you send an email back with, does anyone have any cases that might address X or Y or Z? I don't know that we'll need that, but we will convene the panelists and talk through our thoughts, and if we have a consensus on things, and we will put together a report and recommendation for the Supreme Court to consider. I'm going to take a point of privilege, and then I'll give my colleagues a chance as well. I need to tell you, Judge Johnson, that you are making this difficult, but in a good way for you. I didn't know what to expect before we met you, but I find that you are incredibly committed to your recovery and your sobriety and your family. And I appreciate your persistence in wanting to come back to your job, whether we decide that's the right thing for the institution, and really that's our focus, will be decided later. But I just want to commend you, the way that you have thrown yourself wholeheartedly into recovery and sobriety, and it's not easy. And you seem to have navigated it in the way that one could only wish. And so thank you for doing that. Wherever it may lead you, it's been very impressive. And it is clear to me that you have learned from whatever went on October 18th. You seem pretty darn committed to not let that happen again, not because of professional impacts, but because of the personal impact for you and your wife, your mother, and others who care about you. So I need to note that regardless of our outcome, you've engaged in some impressive work. Want to add?
I agree with everything Judge McBurney said, and I'll add, I think everything you've done is very laudable. Our backgrounds are similar. The question is, do you have value in the system? I think you do. I just don't know what role. This is a very difficult case. I'm a black and white guy. This has got gray all up in there, and this is very difficult for me.
Ditto, everything's been said. I hope you continue to be a role model for others. I presided over DUI court for 10 years, so I dealt with folks who are on that road to redemption, and some have easier roads than others, but it's a lifelong road. And so regardless of what we do, thank you for getting on the road. Thank you for what you've done. And I hope you continue to be that role model and example for members of your community. You can go from your worst days to your best days. And it's not easy, but please continue. And thank you so much for sharing your story with us today.
Bet. I think that's it. Mr. Boring, anything else from the director's side?
No, Judge.
All right, Mr. Kathy?
Yeah.
Well, thank you both for adhering to the time frame that you committed to. It's
We can talk some more.
I'm sure you could, and you'll do that with us not in the room. But I appreciate everyone's time. And Mr. Boring, you'll make sure Ms. Womble gets taken care of.
Yes, sir.
All right, we'll go off the record. Thank you, everyone.
Here.